We are all here to learn, even me, even myself, I'm here to learn. Sometimes you guys give answers that I've never heard of before. But after doing my research, I realized that actually whatever you guys are saying are right. So we are here to learn. We are told that in this profession, learning never stops. Learning never stops. We keep learning each and every day. So as you learn from us, I want to believe and know that we are also going to learn from you. Then again, things keep changing. Laws keep changing again and again. And I believe that right now you guys are so updated since you are in KSL right now, and you are learning a lot. So please be ready to learn. Be ready to learn from us, and we are also very, very ready to learn from you. Now, as usual, we always start with quick questions. Quick questions from you guys. Of course, as we lay ground for our meeting today, just quick questions, just quick random questions about orals. Before we begin, any quick questions from anyone? Any myths that maybe you'd like us to talk about, or that maybe you'd like us to explain? Any worries that maybe you might be having, something that you do not know about, something that maybe you'd like us to clarify? Any quick questions concerning orals? Anyone with any question? This is your time, or you'll forever hold your peace. Any quick questions from anyone? Thank you. Any quick questions? Anyone who has a quick question before we begin? We're giving you guys a chance to ask us questions, because moving forward, we'll be the ones asking questions. I think this is a good chance to have you guys ask 1, 2, or 3 questions. So anyone, again, we also encourage you guys not to feel shy. Don't feel discouraged. Don't allow anyone to intimidate you. One thing that we always say that, guys, when those oral marks come, they're going to be yours. You'll never see them writing Daniel Oduor and Damaris Mutuo, for example. You have 19 or you have 17. Nah. It's just going to be your result. So this is a platform where you express yourself. Take advantage of each and every opportunity. We are lawyers. Express yourself as much as you can. Don't let anything stop you. Nothing. Be as free as you can be. I have allowed you. We have allowed you. Yes, Jacob.
Good evening, Edward. How are you?
Good evening, sir. I'm good.
Yes. Now, I don't know if you had said this earlier, but I didn't capture it. Might you maybe know how this lecturers, the panel, usually tries to distribute the marks? Like what goes to the confidence, what goes to the content, what goes to remembering what and what and what?
All right. Yes, I'm told that there's a way these guys okay, there's a way our very highly esteemed lecturers, I wouldn't say these guys, there's a way that they distribute marks. Now, I can't remember the last time when we were about to do our exams. I think I was really, really careful to know how these marks are distributed, but I can't remember. Nyambura, I think you've joined. Can you remember? Can you remember how these marks are distributed? If you're there, I don't know, file
Yes.
presentation.
Let me just take a photo and share in the group.
No problem. I think that will really help. So yeah, she's sharing the photo in the group, Jacob. I think that will help you to understand and to see how these marks are distributed. But just another way that maybe we can look at it. Okay, Jacob, just try your best to just get all the marks. If you're smart, if you're audible, if you're presentable, if you're ready, then I want to believe that you can even get 20 over 20. But because no one has ever gotten 20 over 20, they'll just give you a 19. They'll just give you a 19 because you're so good. So let's just try as much as possible to ensure that we meet all these requirements, that we go for that 19 that is very, very possible to get. That 19 is very, very possible to get. Imagine having 19 and let's say having another 17 in your oral marks. Man, you're good to go. You're just looking for a few marks. You already have 36. You're looking for a few marks, and you will have passed your exams, because 50 is what you're looking for. Yes, Sharon.
Okay, I wanted to ask, how long does it take in there? Like how many minutes? yeah, how long does it take in there?
All right. Normally it takes 10 minutes, but sometimes could take longer than that, depending on how you are answering your questions and depending on how interactive the session is between, the banter between you and the lecturers. The people who will end up taking 20, not because they are suffering, not because, they haven't answered the questions correctly, but because they are so good, they're so interesting to the extent that the lecturers decide to get into, collateral matters, issues that are not related to KSL and orals. So basically, or normally, ideally, it's supposed to take 10 minutes, but it could take longer depending on how it is, the banter between you guys, and how you answer your questions. The people who so you'll realize the lecturer will ask you one question and you take 5 minutes to answer it, and probably they'll ask you 3 questions each. So you can imagine 3 times 5, 15, 15 times 2, we already have 30 minutes. So it depends, but ideally, Sharon, it's supposed to be 10 minutes.
Okay, thank you.
All right. Any other question before we start? Any other question? Okay. So I want to believe that we don't. Okay. Brenda, go ahead.
Yes, thank you, Adrar. I was asking, will the questions cut across all the units from the 3 panelists, or will it just be depending on the lecturers you meet?
All right. Good question. Good question.
And also, how do you, how can one introduce themselves, in a more presentable way? Like the 3 lecturers, how, what's the starting point, the best way to introduce yourself and all that? Thank you.
All right. Thank you. So introduction, how to introduce yourself, and of course, the number of lecturers, Brenda, they're always 2, not 3, unless they change this year so that you guys have 3 lecturers. But they're always 2 lecturers. Then the units, the questions that will be asked. Now, I appeared before Miss Mongare, our very, very lovely lecturer for civil litigation, and Mr. Okulo, who teaches conveyancing. Now, they only asked me questions on conveyancing, that is Mr. Okulo, and civil litigation, that is Ms. Mongare. So I don't think that you can have a civil litigation lecturer asking you questions on commercial transactions. But I also want to say that, Brenda, it's very possible to have a lecturer who is teaching you civil litigation ask you questions from criminal litigation, for example. However, I want to believe that most of the questions that these people will ask, most of the questions that the lecturers will ask you are questions from units that they teach. Okay, so if you end up before a panel that is consisted of a conveyancing lecturer and a commercial litigation lecturer, it is highly likely that you'll get questions from civil litigation and criminal litigation. Again, Brenda, when you're appearing on that particular day, you won't know prior, the lecturers that you'll be appearing before. Of course, people try as much as possible to try and know. Sometimes you can know because maybe you are number last in the list, or you're number 7, or you're number 5, you're number 6. Sometimes, you're able to know the lecturers that you're appearing before. Or sometimes, again, it's just rumors and you're misled. And when you reach there, you are all gone and you don't even know what's happening. But maybe you'll be able to know the lecturers that you're appearing, but you can't know it like one day to the day that you're going to do your oral mock-ups. No. The day you're going to do your oral exams, no. Probably you'll know it, let's say 10 minutes or 5 minutes to, doing your oral exam. But yeah, it is highly probable that if you're appearing before a civil litigation lecturer and a criminal litigation lecturer, you'll be asked criminal litigation questions and civil litigation questions. If you'll be asked questions from other units, maybe a few. Normally, from the stories that I've heard, I think they usually ask questions from the units that they teach, unless things change. Of course, unless things change. Brenda, that would be my answer. Then how to introduce yourself. We agreed, and thanks for joining today, Brenda, that it's proper that you introduce yourself in relation to everything that connects you to KSL. You know, what is your name? Of course, you begin with your name. Now, I don't encourage people to say their nicknames and, you know, the AKAs and other names. Just say your official name, and I think that will suffice. So you can say your name, say your class, say the name of your farm, then lastly say your registration number. That is everything that connects you to KSL. So I believe that would be enough. However, I know that maybe you can have follow-up questions. Now, these are questions that I can't control. These are questions that probably I don't know about because I won't be in that situation with you. But if you're to be asked anything, maybe they'll ask you your football team. If you get a lecturer who just wants to build banter before you start, the oral questions, you could be asked about your university, the university you went to and such. But I want to believe that it's important that you explain those 4 questions: your name, your registration number, your class, and your farm. And that will suffice. Brenda, does that answer your 2 questions? Okay, thank you. I see you've put thumbs up.
Yeah.
Okay, guys. John?
Thank you, Mr. Daniel Odwar. I would just like to ask, like when you are about to appear or when you appear before a panel, so maybe psychologically, you may even find them when they are tired or when they are in a wrong mood. So how possible that you are going to change the environment of which you want to make some interaction in a way of joke. So is that possible? So maybe you may find them in a bad mood and you want to make some interaction with them by just doing some interaction in a way of smiling, doing some joke, which might not be convincing them or to make them happy or to change their mood. So also, I heard that they used to ask people, "Are you ready to proceed?" In case if you are not in a mood to proceed, is there another way possible that they can adjust or they do what? So that's what I want to know. Thank you.
All right, John, thank you so much for your questions. Again, very pertinent questions, very relevant questions. I'll let Angelo. Angelo, I know you're there. Kindly, you can try and answer the questions that have been asked by John.
Good evening, everyone. Thank you for joining today. I will go straight to the 2 questions on the aspect of a banter between you and the panelists. You must always restrain from going to that route unless you are invited to, because there, you only have 10 minutes to ensure that you have impressed these people to the best of your ability. So if there is any banter or any jokes that you want to create, please just put them aside. Of course, they will always be moody. There are some lecturers that we know, most of them teach class G. So I believe you appear before them, you won't even have that opportunity because it is like someone has wronged them every now and then. And on the aspect of your second question, what was your second question again?
Yeah. When they ask you, "Are you ready?"
Oh yes, I have remembered. Thank you. So, like, if you have a problem that will not enable you to proceed on that day, you can always communicate. I have had colleagues whom their oral were adjourned to a later date. Or if, let's say, for some reason you don't feel well, they can always say, okay, you will come last. It is always a negotiation, but it is not something that you would want to do. And that is the purpose of this session that we have, such that you are prepared, you are ready, unless it is something that will really prevent you from participating in your oral exams. So you ensure that there are no excuses, because once you do that one, so they have already formed an opinion about you. Okay, and that is going to be a real problem for you. So please always be ready and be prepared. Just read. That is what I can say. That's all on my end. Thank you.
All right. All right. Guys, I want to believe that we've tried our best to answer the quick fire questions. The reason why we do this is just to familiarize you guys with orals. Guys, it's not, a deathbed. It's something that you can do. It's very possible. Relax. Relax. You can do it. You will do it. It is fine. So we will continue to do our best to familiarize with you guys. That's what we try and do in the first session of our oral meetings. We try our best to just help you guys to familiarize with what happens there. And guys, you can do it. You can do it. You'll just appear and you'll do your thing and you'll go home and that is it. Now, guys, before we begin, I'd like to congratulate some of us who are here. And I think for me, this is very special and this is very important. This is very important for me. Now, these guys joined us for these oral sessions before they got their CLE results. You can imagine. They walked by faith. They ensured that they attended all these sessions that we've been having with you guys, yet they did not know whether they're going to pass the CLE result, the CLE exams, whether they're going to pass their bar exams or they won't pass the bar exams. But they were here, they've been here, and even today, these guys are here. And guys, this is a testimony that it is possible. It's a testimony that you guys can also do it, that all of us can do it. So please, I know we have some clapping emojis somewhere. I'd like us to clap for Angelo, who just answered the questions right now. I'd like us to clap for Nyambura. She's been with us. She's been, she's been asking questions. She's been contributing in a serious manner. I'd like us to also clap for Hesbon. He's also here and, he's done well. All these guys have passed their bar exams and I'm so proud of these guys. And I can't wait to clap for you guys too. I can't wait to clap for you guys next time. This is a group made of KSL, alumni. I am an alumni. We went through this with Akena Angelo and they've made it. And I believe that you guys will also make it. And you guys will also join us for the next session. Thank you guys for clapping for these people. Now, there are some of them who have also joined us today. I don't know, I'm not very sure of their names, but I'd also like to just congratulate them. We congratulate all of you guys who have done your exams. We congratulate you for passing your bar exams. And guys, the sky is not even the limit. We'll keep going higher and higher and higher. I can't wait for that day when the CJ of this country is going to come from these meetings that we are having. How beautiful will that be? So congratulations, guys. Now, back to business. But guys, we congratulate you so much. We really congratulate you. And thank you so much for, for offering to be here with us today and for always being here with us and for being diligent. May God bless you. So guys, we're going to begin our oral sessions now. And as usual, we always get volunteers. So we'll have a volunteer. We'll ask them questions. So because we are so many and because we are trying our best to ensure that we ask as many questions and we have as many volunteers as possible, one person is going to ask questions, is going to ask one person several questions. I can't say one question. So it will be one person per panelist. So let's say Angelo will ask one volunteer. I'm going to ask one volunteer a certain amount of questions. Nyambura is going to ask one volunteer a certain amount of questions. Hesbon, and of course, Hesbon, I also told you to just send me the names of our very good friends who have also joined us today for the first time so that I know the names even as we proceed. So yes, and I would like us to start with the lady. We always say ladies first, ladies first. Ladies first. So Nyambura, you're going to begin. The newest wakili in town. Of course, I know you've been a wakili all this while, but now that you've passed your bar exams, I know that things are even better. So please, you're going to begin for us today. Ladies first, and so you begin. So you're going to get yourself a volunteer. You can take it away, Nyambura.
All right, thanks, Daniel. So who is ready to start us off today? Someone just raise your hand. This will be easy. We've practiced. Okay, just a minute. I need to see the people who are raising their hands. Anyone? John. There's a John Garang. Please unmute. John, can you hear me?
Yes, yes, I'm hearing you. Yes.
Okay, and you're ready to go.
Oh, sorry. Kindly, I need you to get. Am I the one to ask question, or are you the one to ask and then I answer?
Do you want to ask me questions?
Oh,
Anyway.
I thought that you are the one to ask, then I answer.
Yes, that's it. I ask you questions, then you answer. So I'm just asking whether you're ready to start.
Yes, I'm ready to start.
Sawa, John. Please introduce yourself.
Okay, thank you. My name is John Garang Lual, from class D, from 9, and I'm here to take my oral, and I'm ready to proceed.
Okay, sawa. I just want you to start off with a very simple question. What is the difference between burden of proof and standard of proof in criminal litigation?
Okay, the burden of proof. Thanks for this question. To start with, I will begin with burden of proof in a criminal litigation. The burden of proof is the process of which the accused person have to be proved guilty, and the burden of proof is when the accused person is to be that he has not been proved or has not been proved guilty, but still the process is going to be taken into account.
Okay, so if I'd ask what is the burden of who has the burden of proof in criminal cases, what then would be your answer?
The burden of proof is lie on the prosecution. The prosecution is the one to prove the burden of proof, and it must be proved beyond reasonable doubt. Should be 100%.
Okay, sawa basi. And what's the standard of proof in election petitions?
The burden of proof in the election petition is this can be approved. That should be done in a systematical way, like the process of the election from the beginning, and the evidence that should be given to prove that there are irregularities happened in the election, and the election to challenge the whole process if there are any irregularities in the election, and it should be proved by the petitioner to the IEBC.
Okay, sawa. Moving on, what's the difference between review and judicial review?
Yeah, thank you for this question. To begin with, judicial review is a way of appealing or to challenge the decision made by the the High Court, and to review the process of which they have taken into in your case. Like when you have a case and they have not followed the merit of the case, maybe they heard the law and the process, you have to file the judicial review, and the judicial is like you want to know the issues that are not being put into consideration in your case.
Okay, so if I get a decision at the magistrate's court, can I file a judicial review at the High Court over that decision that has been made by the lower court? Can I file judicial review proceedings on that decision?
If it is in the lower court, you cannot file the judicial review again in that same court. You have to move. If it is magistrate court, you have to file your judicial review to the High Court, because they are not going to change another, but you have to forward your case to the High Court. It depends on the level of the court. Like when you have a case which has been dismissed and you want to make a judicial review, if it is the High Court, you have to file your case to the Supreme Court. So you cannot file the judicial review in the same court when it is when they have that when they have not answered, or they have not they heard the law in your case. So that's why I'm giving the distinction between the Supreme the magistrate court to the High Court.
Okay, what is the last court of determining matters? You know, matters are normally determined either by fact. Facts can be reviewed, and you can appeal on facts, or you can appeal on law. What is the last court where you can appeal on facts?
The last court you can appeal on facts is
I mean, that's for both criminal and civil.
Yeah, the last court you can appeal for the facts is magistrate.
That's the last court.
Yeah.
Okay, sawa. So the last question I'll ask you, assuming that someone has died, let's say it's the husband who died and the husband had children in school. However, when he passed, these kids now have been sent home. There is money in his bank account, and the wife wants the fastest way to access that money so that she's able to pay for school fees. Which grant is she going to be looking for in court so that she's able to pay school fees for the kids as soon as possible?
Yeah, thank you for that question. According to the law of succession, this mother should file a grant in Form 26 of the law of succession to get grant to the succession court, of which she will file that, and together with the supporting affidavit in that court, in the succession court.
So which grant? Just a minute, John. Which grant is she going to be looking for? I want you to tell me the type of the grant.
The grant should be trustee grant.
Okay, sawa sawa. So, Daniel, I don't know whether there are any other questions. I might just give my feedback.
You give your feedback.
Okay, sawa sawa. So, John,
Yes.
one, I want to appreciate that you are confident. You volunteered, so that's good. However, I will be very, very honest with you. You really need to pull up your socks. I'll be very honest, so that you make it for your orals. Now, when I asked you for the difference between burden of proof and standard of proof, so the standard of proof is up to what extent? How are you required? Like the way we normally say in criminal law, the standard of proof is that beyond reasonable doubt. And the standard of proof in civil matters is on a balance of probabilities. So I would have expected that would have been your answer. And then on the burden of proof, you would have said in criminal litigation, the prosecution, which you did, that was good, has the burden of proof. And again, in civil litigation, the plaintiff has the burden of proof unless that burden shifts, because there are some instances where it shifts. Like in criminal, once you've been put on your defense, then the burden has shifted and you need to tell the court why you shouldn't be held guilty. So that was the answer to that question. Then I asked you the standard of proof in election petitions. If you look at the Raila Odinga versus IEBC, the 2017 case, the court held that the burden of proof in election petitions is higher than balance of probabilities, but lower than beyond reasonable doubt. So it is hapo katikati, slightly above balance of probability and again slightly below beyond reasonable doubt. So those were the answers I was expecting for. The other question I asked you was the difference between review and judicial review. So review is reconsideration or re-examination of a decision. Normally that happens if there is new evidence or where there was an error apparent on the face of the record or for any other sufficient reason. And again, the discovery must be new. So you can't just come and say you want the court to review their decision on a matter that was well within your knowledge when the court was listening to your matter. It has to be newly found evidence, and it is important that even if you had exercised due diligence at that time, then there was no way you would have found out about it. So that's what we mean by review. Judicial review is an application made to a higher authority to review the decision made by a subordinate authority. Let's say like the tax tribunals, any like a university or whatever. Then what we are doing in this review is the manner in which the decision was made. Like it's not really about the decision, it's the procedure that was followed to make that decision. And I want it to be very clear to you. You cannot institute judicial review proceeding against a decision of the court. You cannot. The only thing you can do is probably review or appeal. You cannot institute judicial review proceedings against a decision of the court. So I asked you whether you can institute judicial review proceedings against the decision of a magistrate court. I was very specific on the judicial review proceedings. You cannot do that. The only thing you can do is review or appeal, because this will be a decision of the court. And judicial review is not about the substance of the decision. It's normally about what was the procedure that was used to reach that decision. Were you accorded fair hearing? Did they follow the law? That's all about judicial review. So please let it be very clear that you cannot institute judicial review proceedings against the decision of a court. Then the other question I asked you was on father passing on and the mother wants to pay school fees for her kids. There is something we called a special limited grant. Now, this special limited grant, I will look, it was by dint of a gazette notice. I don't remember which one, but it was by dint of a gazette notice. So where a matter is very urgent, extremely urgent, maybe you want money for burial, you want money for school fees, then you cannot wait for the 6 months that are required for a grant to be confirmed. You cannot again wait for the 7 months that will take you in intestate. So it is very urgent that you will need to ask the court to grant you a special limited grant so that you're able to access those funds and be able to pay school fees. So the grant is special limited. Let me just check out the gazette notice. That's the authority. So I'll say you did pretty well because you are courageous. However, please read, go through your course outlines, keep at it, and I know you'll do well in your orals. You have any questions for me, John?
Thank you very much. I appreciate, this is the first time, and I will try my best to do more. There was a quick fire oral I did with a classmate, and I think we will gain that momentum. Only that, once the question is asked, even the little is start vibrating. So that's the issue,
So you did
and it doesn't
well.
mean that we have no capacity to make it. Only that once you ask, you try to remember, and then the question you even ask is trying to get away from your head. You see, so it is a pressure also. But anyway, let's promise when we do this daily, all of us will be okay with that. Otherwise,
Yes,
I
just
also
be
want to know.
composed. If you're tense, I'm saying once you get into that oral exam room, please be composed. Don't tense. Take a deep breath, because I know people who have gone to those oral rooms with a lot of confidence and with a lot of content, and then they get there and they chicken out and they end up scoring very low marks. And it's not because they didn't know, but because they tensed. So you need to, even if it means practicing every day in front of your mirror, just keep at it, keep trying, because I agree with you. You can get into that oral room and you're tensed, you can't remember anything. So please, even if it means practicing before your mirror, just do it, and you'll do well. So back to you, Daniel.
Okay, thank you. Just only one.
Okay.
Assume that you are the one who were conducting the real oral exam. So how many marks will you give? Because I know I performed very poorly. To be honest.
No. You have done well. You have done well. Sawa. Don't usianze kujipatia stress that you have performed poorly. You have done well, and I am sure you will do well with more practice.
Okay, thank you.
Karibu.
All right. That was good. Thank you so much, Nambura. Thank you so much, John. Thank you so much for volunteering yourself. Thank you so much for being the first one. One day when you get that 19, you'll remember this night and you'll remember the practices that you continue to have. Keep going, bro. Keep at it, keep moving. The reason why we have this platform is so that we can make all the mistakes, John. All the mistakes can be made here. Make all the mistakes here, but ensure that you and better. Yeah.
Sorry, there's a question I forgot, and I've seen someone asking about it.
Okay.
The answer to question 4 on matter of fact kindly. So what normally happens, the last court where you can appeal on matters of fact is the Court of Appeal. Now, if you are appealing from the magistrate court, your last court to appeal to on matters of facts is the High Court. So you can only go to the Court of Appeal on matters of law. However, if the matter was being heard at first instance at the High Court, then you can appeal to the Court of Appeal on matters of facts and matters of law. But once it gets to the Court of Appeal, that is the end of it for facts. So if you will be going to the Supreme Court, again, I know you guys know the rule to get matters to the Supreme Court. It is not all matters that can go to the Supreme Court. You need it to be certified as a matter of public interest, and there's another aspect. So that is now when you go to the Supreme Court. And again, it is not a matter of fact. It is a matter of law. I'll just give you guys an example. You all remember the Murwatetu case. The last court of facts was the Court of Appeal. That is where there was last determination of you are either guilty or you are not guilty. But that matter ended up at the Supreme Court. Now, when they went to the Supreme Court, they were not looking for a verdict of guilty or not guilty. They were looking at the legality of the death mandatory sentence. So that the Court of Appeal is normally the last court that you can appeal on matters of fact. However, for matters of law, you can go even to the Supreme Court. Sorry, I forgot to answer that question.
All right, thank you. Thank you so much, Nyambura. Yes, so guys, we keep going, we keep moving, we keep getting better. The more you practice, the better you become. Let's have our next volunteer. Hesbon, I know you're ready. I think you'll take on the next volunteer. Guys, again, don't be intimidated. Don't be quiet. Yeah?
Daniel, a quick one, please, before you engage Hesbon.
All right.
Yeah, just for Nyambura, when she was asking the question of burden of proof, I think, I don't know whether I got her correctly. She talked of what is a burden of proof, and I thought of she was asking about the definition of what the burden of proof is. So could that be another way of, could that, giving the definition, be another way of answering it? Other than giving, like, we know that where it lies, it should be beyond reasonable. Okay, what she has given us. What if the question was, you answer it from the point of defining, so to speak? Does such a situation exist?
So yes, Thomas, you can answer it in defining. And yes, it's okay if you answer it in defining. However, if you answer it, yes, I agree with you, you can define. But if you say criminal, this is the burden of proof. Civil, this is the burden of proof. Now, when you say that, the examiner will know that you know the definition. But again, don't assume it is important for you to say, just say it. But I was asked that question in my orals, and that was the response I gave. And I performed pretty well in orals, so I guess it is the correct answer, but there is no harm in defining. I think I was pretty tense. That was my answer, and I did well. So I think you can answer it in any way, as long as you make sure that your point is driven home and the examiners understand that you know. I don't think there is any harm.
Okay, thank you. Then the follow-up is, when you're explaining about the question of the last court that you appeal on the point of facts, if there is something like that. I'm not sure whether you will say the point of facts or there is an alternative to that. Something I observed is that you gave examples, like when you are talking of if it is on the High Court, the question of facts and on the Court of Appeal, but on the point, the point of law, it will go all the way to the Supreme Court based on the constitutional guidelines. And you went ahead and gave an example of Muratetu case, how it was is that advisable, giving, okay, like you say this and you throw in a case or something like that?
You can, if you're sure, if you are 100% sure about the case. If you're not, hata kama you have a little doubt, don't say it, because it might mess you up. If you're sure, use the case. If you're not, just don't use it. And anyway, it's just very simple. Magistrate court, you can appeal to the High Court on questions of fact and questions of law. And that's the end for facts. The court, you are going to the Supreme Court just on matters of law. Ni kama tu unaanzisha magistrate court. So your first court of mahali una appeal kwanza ni High Court. So hapo uta appeal on fact. But ule mwenye ameanzisha High Court, mahali pake pa kwanza pa kuappeal ni Court of Appeal. So hapo atakuwa allowed kuappeal on facts. So it just depends on your first place of appeal. I think that would be easier. The first place of appeal as a person, you can appeal on matters of fact. I hope that doesn't confuse you more.
Okay, I get you pretty clear. Now, the last one, the last is this. Okay, if you look at like now for the court of for the Supreme Court, it is expressed in the Constitution. Which matters will you take to the Court of Appeal when it comes to the question of law? Now, what I'm asking now is, when where can we get that authority that is specific on the question of facts, being when it is coming from the lower court, the magistracy to the High Court, inaishia hapo. And then if it is inaishia kwa High Court, that is, if it is starting from the High Court, inaishia Court of Appeal, where can we get that authority?
Thomas, you didn't get me clearly. I'll get you the authority. But I didn't say that if an appeal is coming from the magistrate court, inaishia High Court. What I said is, if it's coming from the
question of facts, I got you.
Good.
On the question of facts, inaishia, if it is coming from the magistrate court, inaishia High Court on the question of facts. But on the question of law, inaishia Court of Appeal, right?
Yes. So there is an authority to that effect. Not even an authority. There should be a legislation. Siko sure ni gani, but I know there is one. I'll look for it. In the meantime, I'll also ask the other tutors if anyone has it to just please share.
Thank you very much.
If I may just pop in, really to weigh in on the issue being asked by Thomas. So Thomas, there are civil procedure rules, which I'll invite you to go read. You can go read at order 43. And you can also go read on the appeals, the rules regarding to appeals. They are clear on that actually. If you read the civil procedure rules, it tell you that in the appeal, during the first appeal, you can appeal on fact and law. Then on the second appeal, you can only appeal on law. So you can appreciate the civil procedure rules and also the appeal act, the Court of Appeals Act. Thanks.
Well, right. Thank you.
All right, guys. Thomas, I was waiting for you to say last question. Yeah. So thank you, guys. Thank you, guys, for such an interactive session. So, guys, let's do this. Let's jot down our notes. Let's jot down our questions so that we ask them at the tail end of this discussion. This will help us to create more time for the reason as to why we're here. So, Hezbon, take it away. Let's get the second volunteer.
Okay, thank you, Daniel. Any volunteer to have with me 10 minutes? Exactly 10 minutes. Any volunteer? Can somebody? Okay, can see Onyango George.
Yeah.
Yes, my Lord, Bwana Angelo, can you assist me see the person's
Yes,
raising their hand
yes.
from the side?
Yes, we have Onyango George, we have Orina. So maybe you can go with Onyango George. Onyango George, please unmute. Then Orina will follow you.
Okay.
Okay. Good evening.
Good evening.
I'm sorry for that. I wanted to ask question, but I'm guided by the directive that you've given that we ask towards the tail end of the session. But next time I'll avail myself for the process. Thank you.
Okay. Thank you, Bwana Onyango. Can we have Orina?
Yes, good evening.
Okay, how are you, Mr. Gisori?
I am fine, sir.
Well, you're appearing before me in the afternoon. So I'm giving you the context. So assuming you're appearing before me in the afternoon, on the panel is myself and my lady colleague. Please introduce yourself.
Thank you for inviting me to this afternoon session. My name is Orina Absalom, a member of class G, and my registration number is 2023-0107. I am a member of FAM 36 in that class. Thank you.
Okay, all right, thank you so much, Mr. Orina. Now we're going to have a few minutes to just get your understanding on the interpretation of some issues. So the first question for you, Mr. Orina, is you are really a budding advocate in the city of Shakahola. You're a budding advocate in the city of Shakahola. So one of your cousins actually lost life, and after losing the life, the matter was taken up by a prosecutor of the country. The prosecutor quickly filed the matter in ELC, Environmental and Environment and Land Court in that city. And the matter, the charges were actually, the charge was a murder. The person was charged with murder. So at ELC, you as a budding advocate has been retained by the family of the victim, not the family of the victim, but rather the family of the accused person to represent the accused person. So you are the defense advocate. So you make a certain application to the court, and that application is actually the application merit. What do you think was the application you made, and what was the rationale of the application?
Thank you for the question. I could begin by saying that the alleged offense of my client is murder. Murder being a criminal offense, the court that was highlighted in the case of Republic vs. Karisa Chengo, where it was stated that ELC and courts under Article 162 of the Constitution, the special courts, does not have jurisdiction to determine any other matter apart from that which is a preserve for them. In that regard, the issue that was raised, that would have been raised by me to court, would have been the issue of jurisdiction. In the case of okay, it is stated that jurisdiction is a creature of statute, and a court without jurisdiction cannot handle any matter. So therefore, the application was a miscellaneous application. It was a criminal miscellaneous application seeking that the criminal charges be the matter be withdrawn because the court does not, the ELC court does not have jurisdiction to entertain that matter. Thank you.
Right. Thank you so much, Mr. Rina. So the second question to you is that so you are actually an advocate of High Court of Kenya, and today you are appearing before a panel, and the panel consists of Mrs. Wanjiru and Mr. Gikonyo. So the matter is coming up before the matter is coming up for hearing, and you are the advocate representing the plaintiff. Please introduce yourself and introduce the other. Please introduce yourself and also introduce the other advocate.
You said I appear with who as my co-counsel?
No, just you can have a mention of any person.
Thank you for that question. For that regard, I would begin as follows. May it please the court, my name is Orina Absalom, counsel for the plaintiff. With me is my co-counsel. Her name is Miss Jane. I did not get her name, so Miss Jane is her name. So my instructions.
Hello. Hello. I said you are appearing before High Court. The bench consists of yes, High Court. The bench consists of Justice Wanjiru and Justice Gikonyo. And you're appearing on behalf of the plaintiff. So please introduce yourself and the matter is coming up for hearing. Thank you.
All right, thank you. Sorry for misunderstanding the question. Thank you, Your Honor. Thank you, my lady and my lord. My name is, may it please the court, my name is Orina Absalom, counsel for the plaintiff. I appear before this court, and the matter is coming up for hearing, and I am ready to proceed. Thank you.
All right, thank you. The third question to you. You are a conveyancer or an advocate conducting undertaking conveyancing. So you are doing a transaction where you are you want to dispose or rather facilitate disposal of a certain parcel of land. And so this time you are representing the vendors. You are the vendors. You are representing. Sorry, you are the advocate representing the vendor. You are the vendor's advocate. So usually you understand that the beginning of the transaction, you prepare the agreement. In that agreement, you will have to make a deposit of the first payment, which will be determined by the agreement itself, as guided by the LSK conditions of sale. So that amount is agreed upon. Parties execute the contract, and a completion period is set. So now it is on the completion. It's on the completion date. So you have all met for the completion ceremony. And so what is required at this stage is that you want to exchange some completion documents. And remember, your client is a company, and that company is the vendor. What do you think shall be the completion documents you'll be presenting to the purchaser on behalf of the vendor?
All right, thank you for the question. The question is raising very pertinent issues of conveyancing. In that regard, I, as the advocate for the vendor, and the vendor here being the company, the very first document that I would present to the purchaser's advocate is, one, the title of the property. Number two, it is the certificate of incorporation of the company. Number three, it is the power of attorney, because the company cannot appear by itself. And number four are the transfer documents. All right. if the land is for agricultural use, then we'll have to have the land control board consent. Those are the documents that I can be able to remember. Thank you.
Okay, thank you so much. I have with you 3 minutes, and in these 3 minutes, kindly I request that you use 30 seconds to respond. No, I have 2 minutes actually. So my last question to you is, a client comes to you, a client tells you that I actually purchased this land from Absalom, and in purchasing this land, Absalom was a good friend of mine, so that we didn't even need to have an agreement written down. So I just sent him the money. I sent him an M-Pesa transaction, and you have the receipt of that money. And so the land was supposed to be given to you, but unfortunately, the guy is been reluctant to give to you the ownership of that land. So, as an advocate representing that person's kind of claim, what are some of the legal issues you are going to raise in writing a legal opinion to that person?
So I am the advocate representing the purchaser.
Correct.
All right. Thank you for that question. I would like to point out that the very first things from the apparent record of the question is that the contract was not in writing. Impliedly, therefore, there were no documents to be signed in that regard. As the purchaser's advocate, I would like to state that the law of contract provides that any contract with regard to the disposition of land or purchase of land should be in writing. The same is provided for under the Land Act. It proceeds to provide that any contract of land that is not in writing is unenforceable. So with that regard, the purchaser is unlikely to be able to pursue a legal action against the vendor if the vendor does not transfer the property to him in that regard. Also, if the contract was not in writing, further, it's required that any documents with regard to the transfer of property should be stamped. So the Stamp Duty Act provides that the documents that are intended, the instruments that are intended to transfer interest in property be stamped. So in that regard, the same was not done. So it will be such a contract would not be enforceable in a court of law. Thank you.
Wow, thank you so much. That was you and I for the 10 minutes. So, Mr. Oduor, just allow me to give a quick review. But before then, allow me to commend Bwana Absalom. He's really done so well. And this is the reason why I feel like he's done well. Absalom has been able to use the IRAC or FIRAC formula in answering my question. I realized that he highlighted the fact, he identified the issue. In fact, he used some law, which law included the case law and some provisions of law. He analyzed it well and concluded. Just to me, guys, if you're using that formula of FIRAC in your answering of questions, but ensuring that you stick to time by yourself, then that is the best way, the best approach to take. So thank you so much, Absalom, and that was a good way. 30 seconds for the review of the questions I asked you. The first one was about the murder case, where the matter was filed in the ELC. And in fact, you were able to mention the Karisa Chengo's case. I'll invite guys to read on that case, the Karisa Chengo's case, where some of the members of the bench were the ELC judges. So do they have jurisdiction of the matter? They didn't have. So it's a good case. So he was able to analyze the situation is that the case has been filed in a wrong court. So the court does not have jurisdiction. But he failed to mention the application which I asked. But then the application is a PO, a preliminary objection application. Then on the second question of introducing yourself, I also noted you need to go brush on that, how to introduce yourself. You need to know the bench. If it's the magistrate, you know, you're addressing the magistrate as a honorable, your honor. If it's the judge, you know, you're supposed your ladyship, your lordship, my lady, my lord. You're supposed to be very careful, especially in this case. I asked you, there was a lady and a gent. You don't just say my lady or my lord and stop at that. There are two, so recognize all of them. Then introduce yourself as you. Don't say Mr. Of course, you didn't say that. You say, for example, my lady, I am Ooko in this matter representing the plaintiff. Mr. This and this is present for the defendant or for the respondent. The matter is coming up for hearing, and you stop at that. Then on the question of completion stage or completion document, you really did so well. Then on the question of the last question I asked you on the aspect of contract of land to be in writing, you answered it so well. You got the trick. I was testing you on whether you understand that all contracts of land or all contracts purporting to transfer an interest in land must be in writing. You really got the sections of law, which is Section 3 of the Law of Contract Act, Section 38 of the Land Act, and Section 44 of the Land Registration Act. Thank you so much. And if you appeared before me, or if you appeared before me or any panel I know, then you honestly get an 18 out of 20. Thank you.
Thank you.
Thank you. Thank you so much for that. We can have the next person, Angelo. Angelo, you're next.
All right. Thank you, Daniel. Thank you, Esbon, and all our participants. I will also have my 10 minutes. We will finish in the 21, 28, or 29. So I can't see hands. There were a lot of hands before. Oh yes, were you here? You can unmute. Thank you, Okumu, and your colleague. Oduor Donna, you will be next, and then Okumu Justice, you will follow her thereafter. So were you here? Please unmute. Good evening.
Good evening to you.
Yes, I'm not going to ask you to introduce yourself. We will just go into the business. Can you please define for me your understanding of the term lease?
A lease refers to where a person called a leasee rents out their property to a lessor, either for a certain period of time, for a certain an agreed amount of money, or for periodic payment.
Okay, thank you. Can you please tell me what are the elements of a lease?
The first element is it has to be in writing. Number two, there has to be the subject matter of the lease. Number three, consideration, that is the value of the subject matter, then the duration of the lease. Yeah. Yes.
I'm sorry. Have you reached leases yet or not yet?
We've not done leases.
You have not done leases?
Yeah.
Okay. And if I ask you the second question that I was to ask in that unit, for you to give me the differences between a lease and a license, would you be able to attempt at least two differences between a lease and a license?
Attempt, maybe I can get one. I can remember one. So
Okay, give
one,
me that one.
a license is merely a permission that is what that one is granted to enjoy, use, or access, maybe if it's a property. But a lease has proprietary interests that are transferred to the lessor. I think that's what I can remember.
Okay, thank you so much. Ms. Oyusia, you are the lead legal counsel attached to the Directorate of Criminal Investigation, DCI. So, Corporal Kimngetich, I've asked you to assist him in the Shakahola investigation. So, he wants you to help him on how to prepare his investigation and also something about the prosecution files. So can you please tell me how can you assist or maybe give me the content of a prosecution's file?
Thank you for that question. First, I will not follow the orders of the SAP file. I'll just say what I can remember. I know there is a charge sheet sets out the particulars of the offense and a statement of offense. We also have the list of witnesses. We also have the witness statement. That's the statements that of the witnesses that the prosecution intends to rely on. We also have the statements of the, okay, let me say expert evidence. That can be maybe if it's medical reports, forensic evidence. We also have the investigation diary. We also have the custody report. That is if there are any arrested persons or persons who are in cell. It contains the details when they were arrested, the time, anything that was recovered from them, and the covering report. That is what I can remember.
Okay, thank you. My second last question, can you please tell me if you know something or you can differentiate for me the following two cases, Denegu versus Stevenson and Rylands versus Fletcher. Just a single difference between those two authorities.
Okay. I can say that first, the case of Donoghue versus Stevenson is the locus classicus when it comes to the tort of negligence. And it lays down, it establishes the three ingredients of negligence. That is duty of care. You owe someone a duty of care, you've breached the duty, and as a result of that, they have suffered some damages or injury. While the case of Rylands versus Fletcher deals with strict liability, and strict liability means that, for example, if I keep within my control something that when it escapes is likely to cause injury or harm to the public or the people around me, then I will be strictly liable for that. With liability, there is no need to prove that I was negligent, but in the negligence, or in the case of Donoghue versus Stevenson, the negligence has to be established for me to be liable.
Very well, very well. Finally, or if not, then we shall see. Can you please give me at least 3 elements of defamation?
The first element is the statement is untrue. That's the statement the defendant. Number two, the statement is either written or said to a third party. Then lastly, I can say that that statement has lowered or can lower the reputation of the claimant to a reasonable member of the society.
Very well. And if you may proceed further, please give me at least 2 defenses to defamation.
The first defense to defamation, I can say, is apology. That's where the defendant renders an apology and maybe decides to withdraw the statement. Then we have damages. Where the defendant can agree to compensate the complainant for that. Then we have, yeah, that's what I can say.
Okay, thank you. And then maybe finally, can you please give me 2 types of computer hardware that you know?
We have mouse, we have the desktop, the what else? We have PC, not PC, central processing unit. I'm not sure.
Okay, so now I will use the remaining 2 minutes to give my response, but I won't have much, except that maybe on the aspect of conveyancing, that you had an issue because you have answered my questions clearly and perfectly. To be sincere with you, I would really give you a lot of marks, which I am unable to declare for security reasons, but you did really well. So if I am to comment in the next 1 minute, so you see, when you are defining a lease, please sometimes you have to show people that you have read. Most of the definitions in these regards are found in Section 2. So you can use the definition provided under Section 2 of the Land Act. And you take a simpler version. I know the conveyancer, Honorable Odur, will give you a technical definition. But for me, I can take that a lease is an interest in land for exclusive possession for a specified period of time. I can take that particular definition under Section 2. So I know maybe Section 2 is somehow longer, or if it is shorter, but I would take that particular definition. And when someone asks you about elements of a lease, you see, you are trying to look like lease like a contract. Of course, it is a contract. But in this sense, I'm talking about a lease. You see, when I was asking you to give me differences between a lease and a license, you came out clearly. So I was actually expecting you, because this thing should be on your fingertips, like it must have a defined area, must have exclusive possession. There's something called certainty in duration of time, defined parties, but there are majorly 3 of them. I have not given you the same clearly, but there are 3 that always stand out. So it's such that when someone now asks you about the differences between a lease and a license, then the first thing that will come in your mind is that lease, it has something called exclusive possession. The other one requires permission to use premises, just like the way that you said before. For a lease, you can assign or transfer. For a license, it cannot be assigned or transferred. Okay? You can say again, a lease not easily revoked and can only be terminated on notice. A license, you see, it is a license, maybe a parking space, something like that. So you will do what? You will can be revoked upon reasonable time. Now, so that is it. My time is up. I have taken Daniel's time by 1 minute. Maybe I will compensate later. So that is all on my part. All the other questions, you really answered them well. Congratulations. Keep it up. and you will really do well. So unless if you have something to say, or maybe a question I might have forgotten that you want me to answer.
I don't have any question. I think the part on leases, you've clarified that.
Very well, very well. Thank you. Daniel, take it away. I believe we had someone who was to come before, after her. Maybe that person can unmute.
Please, can I ask before you go, please? I beg
All
your
right.
permission. The elements of list, please, I was taking them down. If you can please repeat for our sake.
Okay, okay. It must have a defined area. Then it must have something called a determinate term, which I said certainty in duration of time. And then the more important thing is exclusive possession. Is that okay, Mr. Onyango?
Thank you very much. I appreciate.
All right, you're welcome. Daniel, please take it away. We had someone who was to come after Weyusia.
Yeah. That was you. Someone called Oduor, I think. Yeah.
Yes.
Someone called Dana or Donna or Dur. Yes.
Yeah. Someone called Donna. Hi, Donna.
Hello.
How are you?
I am fine, and you?
I'm good. Kindly introduce yourself.
My name is Sudur Donateno, registration number 2023-0158. I'm a member of Class D, Farm number 6.
All right. That's nice. Who is your LPM lecturer?
LPM lecturer is Miss Betty Mishuki.
Okay. What was your last class on LPM?
In the last class, we discussed job analysis. We were basically finishing up on job analysis. Yes.
All right.
Yes.
All right. All right. That's okay. Donna, could you please just tell me the different types of pleas?
Pardon?
The different types of pleas.
Please. So in criminal law, there's the plea of guilty, where the accused pleads guilty, the plea of not guilty. There's the plea of outre fois acquit, where the accused pleads that they were previously convicted, they were previously charged, and outre fois convict, they were previously charged and convicted of that crime, and outre fois acquit, whereby they were previously charged and acquitted of the offense. These are the 4 I have now.
All right. All right. That's fine. What about the types of plea bargaining?
Plea bargaining.
Yeah, the types
Well,
of plea bargaining.
I only know plea bargaining as it is, whereby the accused person enters into a plea agreement with the prosecution. So I'm not sure that there are types of plea bargaining.
Okay. What about the rules regulating plea bargaining?
The rules regulating plea bargaining. First is that there are some offenses where you can't get into a plea bargain. For example, the offense of treason. And before entering into a plea bargain, the victim must be included in the process, and it is not necessary that. Okay, there are times where the victim may refuse to accept the plea bargain, but the prosecution will not necessarily rely on that and may just go ahead and enter into a plea agreement with the accused person. And also in plea bargaining, in plea agreement, the accused must not collude with the victim or the complainant to defeat justice.
All right. That's okay. I hope you can hear me.
Yes, I can.
All right. So my good friend Hesbon comes to your chambers. Let's assume you've already been admitted and you now have your chambers somewhere in Upper Hill. He comes to your chambers and he tells you that he has a client who pleaded guilty during the trial. This client pleaded guilty during the trial, and this client has in fact been convicted by the court after pleading guilty. However, this client would like to appeal. That particular conviction. What would be your advice to Hesbon?
Well, you said the client had pleaded guilty and was convicted by the court.
Correct.
Okay. So if he was convicted and probably sentenced, then I'll advise Hesbon to tell the client to appeal. If probably it was in the magistrate court, he or she will appeal to the high court. And if it was at the high court, then the client will appeal at the Court of Appeal.
All right, that's okay. So do you know about the case of Adan versus Republic?
Adan versus Republic, I have heard of it, yes.
Okay, what's it about?
Unfortunately, I can't remember the facts. I only know it's in criminal law.
All right, that's okay. All right, to the next question. What is an ID parade and what are the rules regulating ID parades? Just give me three rules after defining what ID parade is.
So an identification parade is a process whereby the complainant tries to identify the suspect who he or she thinks committed the crime. And the rules, first, one rule is that in the parade, the parade must have a total of 9 people, at least 9 people with the accused, sorry, not the accused, with the suspect included. And then the witness or the complainant should not see the suspect before the parade. And then the investigating officer is not supposed to be the one conducting the parade, though he or she may be present at the parade when the parade is being conducted.
All right, last question, Donna. Maybe let's say someone has sent you a message or asked you this, and the question is the right to legal representation by the state an absolute right? Is the right to legal representation by the state an absolute right?
So the right to legal representation is not an absolute right. It is provided for, I think, under Article.
Are you sure, Donna? The right to your statement is the right to legal representation is not an absolute right. Are you sure? And are you answering my question?
Could you kindly rephrase?
My question is the right to legal representation by the state an absolute right?
Well, the state is supposed to provide legal representation to an accused, but it is not absolute. It is not a must that the state must provide legal representation to an accused person.
Why, Donna?
Because the state is not obligated. It can only provide legal representation to persons who have been accused of offenses whose what's the name? Whose sentence is capital, and there are also special groups of people who are entitled, because there are very many criminal cases, and having to provide legal representation to each and every accused person in these cases will not be economically sustainable, because the state does not have all that resources. And also, I don't think there are enough advocates to be representing every accused person in all the courts.
All right, fair enough, Donna. Thank you so much for your answers. I think you answered well. In my opinion, you didn't let me down. I think you answered very well. I think you're very confident. I think you're so clear, you are confident, you knew your thing, you stood by your answer. Now, the reason as to why I asked you the last question twice is because I realized you are answering your own question. I asked you the right to legal representation by the state. When you started answering the question, you're talking about the right to legal representation. Those are two different things. I'm talking about the state and not any other right. If you talk about the right to legal representation, you're opening a whole new debate and not the debate that we were talking about. So again, when you're answering questions during orals, ensure that you're answering the question that you've been asked. So don't just answer another question. But well, I asked you the question again. You came, you came back, and your answer was very, very clear. Donna, if I might ask you, where is it in the Constitution, the right to legal representation by the state?
I think it's Article 51. 50 on the right version.
You think, or you're sure?
It's either 50 or 51. I am not sure of the exact one. Yes.
Okay. All right. To have an advocate assigned to the accused person. Okay, so we're looking at Article 50. If you have your Constitution there with you, Article 50. And Donna, I hope you have it because you're going to read it for us. Article 50. H.
Let me just open it right now.
Article 52H. I know you'll never forget this one after, but your answer was correct. And even as you read, you'll realize that your answer is correct. But I wanted you to use the Constitution because this is coming straight from the Constitution. And this is a debate that we've had so many times. The people who think, Donna, the people who disagree with you and think it's a must. It's a must that if I don't have one, then the state must provide. Are you there?
Almost in a minute.
All right, let me read it for you. So, 52H. Oh, I see you're there. 52H.
Article 52H. Every accused person has the right to a fair trial, which includes the right to have an advocate assigned to the accused person by the state and at the state expense if substantial injustice would otherwise result, and to be informed of this right promptly.
Thank you. Yeah. So if you read that, there's that word if. To me, this is not a right to every single person. It has, for lack of a better word, I'd say a caveat or an obstante clause. So they're saying only if substantial injustice would otherwise result. Now, again, the questions where we could have substantial injustice, that's a question for another day. But I want to agree with your sentiments and with your direction, that it must be, cases like rape for certain group of people, like we have children, we have, cases like murder, such serious issues. But where someone has stolen their neighbor's chicken, I don't think they should claim that right. Now, on to the next question. My first question was on types of pleas, and I think Donna, you ate that very well. You cut your cake, you ate it very well. Plea of guilty, plea of guilty, plea of not guilty. You can also refuse to say anything. I don't know how you'd call that. Then we have atrephois acquit and atrephois convict and pardon. And I think you explained those very, very, very well. Types of plea bargaining. Now, you said that you have no information about this, Donna. Please go through your book again, go through your notes again, and you'll see it somewhere. But they include types of plea bargaining include charge bargaining, facts bargaining, and sentence bargaining. I'll repeat: charge bargaining, facts bargaining, and sentence bargaining. What's charge bargaining? Withdrawing some charges. So you might find that you are being charged of 5 things, and through plea bargain, you can agree with the prosecutor to withdraw some charges. Then the second one, which is facts bargaining, you bargain with the prosecutor not to use some facts anywhere else. You bargain with this prosecutor not to use some facts anywhere else. So maybe the offense that you committed could be this now, and later on another thing. Or you've committed one offense and later on you could be convicted of another offense because of the facts of the case. So that is facts bargaining. Then sentence bargaining, of course, that is very clear. You try to bargain so that you can get a least severe sentence. So Donna, charge bargaining, facts bargaining, sentence bargaining. I want to believe that now you know that. I know that now you know that. Anyway, then rules of plea bargaining, you are very clear. I loved that. You answered correctly. Adan versus Republic, Donna, please just try after this. Go through your notes. If you don't have them, please, I think I can share them with you. But I know that if you just look for it, you'll get it. Adan versus Republic is on the procedure in recording a plea of guilty. What is the procedure in recording a plea of guilty? Now, in Adan versus Republic, these rules were given. These are the guidelines that we follow when you're talking about plea of guilty. One, the person pleading guilty, it must be that the person pleading guilty fully understands the offense with which he or she is charged. Two, where the offense is punishable by death, the court recording the plea of guilty must show in its record that the person pleading guilty understands the consequences of his plea. And three, the prosecution should then immediately state the facts, and the accused should be given an opportunity to dispute or explain the facts or to add any relevant fact. Four, if the accused disputes the facts or raises any question of his guilt, his reply must be recorded and a change of plea entered to not guilty. Five, if there is no dispute, a conviction should be recorded and a statement of the facts relevant to the sentence together with the accused reply should be recorded. Now, the reason why this is important, and this is something that was shared by a lady that I think Angelo and Hesbon would know, called Victoria. And this happened during it's called clinical. There's this lady who was, charged with murder. And, they asked her, do you plead guilty to murder? And her answer was, yes, I plead guilty. I killed her. But then they started telling her the facts and telling her that, she had malice aforethought. She wanted to kill this lady. And she was like, no, judge, that was not the case. I was defending myself. In fact, this is what happened. She tried to attack me. This happened. That's why I ended up cutting her neck and killing her. Now, because of that, because the court tried their best to explain the difference between murder and manslaughter, the charge was changed from murder to manslaughter. Why? She had no intention. Now, imagine a situation where this was not explained to her. She could have pleaded guilty to murder. That's why it is important. That's why Dan versus Republic is very, very important. Now, I want to move very quickly. ID parade, you got it. That was a clear cut. Rules regulating ID parade, you got that. Clear cut. Again, thank you so much, Donna. You did so well. You did so very well. I'm very impressed. All the best, Donna. All the very best. Do you have any question for me?
No, I think I've gotten that once I had the question.
All right. Oh no, one thing I'm forgetting. I asked you about, this Hezbon has come to your chambers. Yeah, she's telling you, he's telling you that, he has this client who pleaded guilty during the trial and, has actually been convicted of that particular offense. I'd like you to look at section 348 and 379 of the CPC. Now, those sections say this, that no appeal is allowed in the case of an accused person who has pleaded guilty and has been convicted on that plea, except as to the extent or legality of their sentence. Okay, so that is what I wanted you to tell me. They pleaded guilty. Okay, they've been convicted of that particular offense, and they want to appeal. Now, I wanted you to explain to me that they cannot, appeal on the fact that, they were convicted. The only thing that they can appeal on is on the legality of the sentence, nothing else. What they'll be saying is the sentence is too long, or this and this and this, but not the fact that the facts were crooked. Oh no, I didn't do it. Oh no, I ought to have been innocent. I ought to have been declared innocent, acquitted, and all that stuff. Okay, so where you have pleaded guilty and you've been convicted of that particular offense, the only appeal that you can have is an appeal to the extent of legality of your sentence. However, if you can prove that there was duress, that's why you pleaded guilty, then things will be different. This was held in the case of Dende versus Republic. Okay, Donna, that's okay? That question is now answered.
Citation of the case.
Dende versus Republic, NDEDE versus Republic, 1991. The sections are section 348 and section 379.
Thank you.
All right. All the best, Donna. If I was a lecturer right there, I could have given you very, 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 very high marks. We'll go to the next person, and that's Nyambura. Nyambura, I think Angelo has a list of people. Maybe Angelo can tell you who's next.
Yeah, Justice Okumu, please unmute. Or is it Okumu Justice? Okumu, are you there? Okay, please let's raise our hands. Maybe he's having a challenge.
I am, go ahead.
Okay. And the rest who would like to follow, please also raise your hand as they continue. Thank you. So that we can have flow. Honorable Nyambura, please go on.
Hi, Okumu.
Hi.
Please introduce yourself. Assume you are appearing in the morning. Okumu, I can't hear you. Just unmute your mic and leave it unmuted.
Okumu, are you having a challenge with your gadget? We are running with time.
Okumu, maybe you can drop us a chat. Just send a message. I think maybe you have a problem with your mic. So Angela, I think maybe you can move to someone else. Okumu,
Yes,
maybe
yes, please. Yeah, as he sort out the issues, maybe we can have the next person. There were a lot of you. Please maintain your hand up if you raised it before, like that we can proceed as quickly as possible. Please maintain your hand. I'm only seeing for Kumu. Yes, Angela. Angela, please unmute and proceed. You will have your 10 minutes with Nyambura. Thank you. Others, please raise your hand. Proceed. Proceed.
Hi, Angela.
Hello.
Please introduce yourself.
Good morning. My name is Angela Kemtogise, a member of Class D, Farm 10, and my registration number is 2023-0568.
Okay. So, Angela, what comes to your mind when the case of Solomon versus Solomon is mentioned?
When the case of Solomon versus Solomon is mentioned, I could think of company law, and how when it comes to registration of a company, the moment you registered it, the company becomes a legal entity. Hence, the rights, when it comes to liability of the company can be sued, and it has its own rights. It can own property and do other things a legal person can do. A legal person can do.
Okay, that is great. What types of companies do you know in the sense of limited and limited? Okay, just go ahead.
Can you come up again, kindly?
The question is, I think that should be Section 5 of the Company Act. A company can be limited either by shares, and a company can be limited either by guarantee. So what is the difference between limitation by guarantee and limitation by shares?
Limitation by share is where a company is limited to the unpaid, is limited to the amount unpaid by members to which they had made a statement to pay. And limited by guarantee is where members have made a promise to chip in when the company is liquidation to pay a certain amount of guarantee.
Okay. Now, what is the minimum amount you need to have if you're planning on establishing a private company?
I think for private, there's no minimum. I think the one that has the minimum is for public companies.
What's the minimum amount for public companies?
I don't remember the exact amount, but about 5. Okay, don't remember the amount.
Okay, sawa. I believe you've done partnership.
Sorry?
Have you done partnership?
Yes, we have.
Okay, what are the different types of partnerships that you know?
We have limited partnership, general partnership, and limited liability partnerships.
What's the difference between those two partnerships?
First of all, general partnership and limited partnership are guided by the Partnership Act 2012, I believe. General partnership is where the partners have unlimited liability. Limited partnership is where at least one partner has to have unlimited liability, whereas the others can have limited liability. So we have both. In limited liability partnership, the liability of the members is limited to the amount of shares contributed to the partnership.
That is for limited partnerships.
Limited liability partnership, where
that is limited liability. How about limited partnership?
Limited partnership is where, okay, first of all, there should be at least one general partner, and the others can be limited partners. So the general partners do not have limited liability. They are liable jointly and severally, whereas the limited partners are liable to the extent of the contribution made to the partnership.
Okay, sawa sawa. What are different ways of breaking up a partnership? I mean a partnership, sorry. How do you break up a partnership? Or at what point does a partnership break up?
A partnership can be dissolved when the partners are, I think, less than 2. Then the partnership, of course, cannot continue. It has to be at least 2 partners. And I'm also thinking in the lines of when a partner is also allowed to leave. So one can resign. Yeah.
Okay, the last
or when
question.
one dies. Mm-hmm.
Okay. The last question will be, if a partnership breaks, can the remaining, let's say there were 2 partners and 1 person dies, the partnership number falls below 2. Can the remaining partner keep up doing business on behalf of the biashara of the partnership?
No, that is not possible. The partnership should have at least 2 partners. It should not fall below 2. So the moment one dies, I think you cannot continue operating. I think there's a limited amount of time within which you're supposed to get another partner. Otherwise, it won't be considered a partnership.
Okay, sawa sawa. So let's just go through the questions real quick. Solomon versus, first of all, you did pretty well. That was really good. Solomon versus Solomon, you answered perfectly. Then a company being limited by shares or a company being limited by guarantee. That one you answered perfectly. Shares are already the ones you have in the company as an individual. And then guarantee, it is someone saying that in the event that this company is insolvent or is being liquidated, then I commit to pay this much. So that is guarantee. You're giving a guarantee. So that was a perfect response. Types of partnerships, you did well. General partnerships, limited partnerships, and limited liability. How you differentiate those 3 is you can start by general. There is no limitation. I mean, partners are not limited, and it doesn't have to be registered. Then for a limited partnership, some are general. That meaning some are not limited, and some have limited liability to the partnership. And a limited partnership has to be registered. Then limited liability partnerships, all of them are limited by liability, and it has to be registered. And as you said, the first 2 are guided by the Partnerships Act, and the LLP is guided by the LLP Act. So you did well on that one. Then the other question I asked you is how you can break up a partnership. So it is, as you said, if you can say the partnership purpose has become illegal, let's say the partnership was formed to sell cigarettes, and then there has been a legislation that has been passed saying that cigarettes are now illegal commodity. So that's a way a partnership can break, because you have no purpose being together anymore. Then the other one, as you said, is when the number falls below 2. And another one is where you have decided as partners to dissolve. So there are different ways where how a partnership can break. Now, there's a question I asked you on whether business can continue if the partnership has broken. Now, you need to know that for general partnerships and limited partnerships, business can continue for 1 year for purposes of paying the debts of the partnership. So the limit is 1 year. So you can keep doing business to pay debt of the partnership if the partnership had any debt. So you are allowed to keep doing business for 1 year. Now, if the partnership is an LLP, after breaking up, you can conduct business for 2 more years. However, you need to understand this is if there is no perpetual succession as per Section 6 of the LLP Act. So generally, LLPs, it is perpetual succession. So even if someone dies, the business will continue. However, there cannot be perpetual succession if the number falls below 2. Like you cannot have a limited liability partnership if you are alone. So that is the only instance where an LLP will break up, and then you're allowed to do business for 2 more years.
Thank you.
All right, I believe Nyambura is done with a candidate, and I can take the next person. Do we have any volunteer from your side, Angela?
Not yet. Please, guys, tuinueni mkono. We had a lot of people before, but they have dropped their hands. Please raise your hand. Twende teke. Mwenda Victor, thank you. Unmute.
It's not a question. I'm not trying to. I've written a question on the comment section with regards to the issue that Daniel stated on the issue of sentence bargaining, because there's case law that says in plea bargaining we cannot enter into a plea bargaining on the issue of sentence, because that will amount to the prosecution usurping the power of the court to enter a sentence. Could you please clarify kindly?
Okay. I believe Odor gave a directive before. Maybe you can allow him to respond to you at the tail end of this discussion, if that is okay. Wenda?
That's totally okay. Thank you.
All right. Thank you. Esbon, you can go with Mwiti, Eddie. Please, Eddie.
All right, thank you. Mwiti, Eddie, kindly unmute. Has he unmuted?
Not from my end.
Mwiti, Eddie.
All right, guys, we are over 370. Please, let's raise our hands. We still have under 1 hour to go.
I can see Mutunga Nicole.
Yes, Mutunga Nicole. Mutunga Nicole, please proceed and mute.
Good evening.
Good evening, Nicole. How are you?
I'm well, thank you.
You're appearing before me and my colleague. So it's morning. Can you introduce yourself?
Good morning. My name is Nicole Mutunga. I am in Class C and my admission number is 2023-1601.
All right. Thank you, Nicole. So, Nicole, I'm going to have with you 10 minutes. Our time will stop running at exactly 10:20. So I'll begin. So you really have an interest in public litigation, and you've secured a job in the office of ODPP. You've secured your job in ODPP. You've been employed as a young prosecutor in the office. So there is this matter that has been ongoing, and you are requested to come on conduct on that for that matter for purpose of prosecution. So you do not know exactly what the matter is concerned with, or rather what the person was charged with. So at the back of where your seat is are very many files. So you check, you see their prosecution's files, and you really want to know what charge was this person, or rather which charge was preferred in this file in this matter that you want to come on in your conduct. So there are several files named from. Of course, you understand how prosecution's files are named. So would you kindly tell me which exact prosecution file will you check for the charge sheet?
For the charge sheet, you'd have to check subfile G following pursuant to section 214 of the CPC.
Okay, thank you. Then Nicole, I have another question. What do you understand, or will you kindly distinguish to me these two doctrines in probate, the doctrine of ademption and the doctrine of lapse?
Okay, the doctrine of lapse is where the testator wishes to dispose of their property in their will. However, prior to their death, or they dispose of their interest in land, or that that property is destroyed. And the principle of ademption is where the beneficiary under the will predeceases the testator.
Well, thank you, Nicole. Another question I have for you. So you have been appointed as a lawyer to represent a certain family. You do you apply for the letters of administration because there was no will, apparently. You apply for the letters of administration, the same are granted in 2010. And then in 2011, or rather 2010, the administrator appointed starts with administration of this estate. He administers some parts of the state, but in 2013, he actually leaves the country to travel to Uganda. So unfortunately, during the time he's in Uganda, there are some parts of the state that must be administered. And this person is actually not in the country. He's traveled to Uganda. So you are advocate representing the family, and the family has consulted you. How will you advise the family, and what type of grant do you think you'll apply in this circumstance?
Thank you for your question. I'm not very sure about the specific name of the grant, but in cases where the administrator of an estate dies prior to, or leaves the country prior to the entire estate being distributed, you can apply for a grant to have them replaced as an administrator of the estate.
Okay, another question for you, Nicole. You start your own law firm just after admission in 2026 or 2025 thereabout, and you really want to have a very, very pretty but professional front office. So what do you think will be some of the items that will be found in your front office?
So some of the items that would be found in my front office would be a waiting area, a reception desk, a computer for the receptionist, and also sufficient lighting in line with the requirements of the Occupational Health and Safety Act, and sufficient ventilation in line with the Occupational Health and Safety Act. I seem to have lost you. I don't know whether it's just the fact that you're unmuted. No, you're
Oh,
muted.
sorry,
Sorry.
I know I unmuted myself. Sorry. So the question I have for you is a conveyancing related question. So you understand that in a conveyancing, there are usually various parties. It can be a tripartite type of a conveyance. There can be a two parties. And so these parties are usually represented so that we have, for example, if it's a land transaction, you have a vendor's advocate, and we have a purchaser's advocate. But then for you, you've just been admitted and you really have a key interest in conveyancing. You understand both the roles of a purchase advocate, both roles of the role of vendor's advocate. So there are these two clients who come to you. One is a vendor, one is a purchaser. So they want you to assist them to undertake this conveyance. And the request is they need you to represent them together. What will be your reaction?
My reaction would be to avoid representing both the advocates in the matter because it raises a potential conflict of interest between the two clients. And it's generally unadvisable to advise two parties within the same conveyancing transaction. So I would probably inform them of the conflict of interest and try and recuse myself from the matter.
Okay. The second last question to you is you've been occupying a certain parcel of land, and one morning you wake up, you find a very, very big poster. It's written, we shall be destroying this parcel of, we shall be destroying your house and evicting you from this premise tomorrow at 8 a.m. So that is the writing you've seen in the morning. They'll be destroying and evicting you from that parcel tomorrow at 8 a.m. So you quickly run to an advocate, and you actually have some knowledge, legal knowledge about the matters of eviction and really everything. So what do you think your advocate is going to do if he's going to move to the court? What kind of application is the advocate going to move to the court, and what other suit, if any, is the advocate going to file to the court?
So initially, the advocate would file for under a certificate of urgency and a notice of motion to have some sort of temporary injunction issued pending the determination of the suit. And they would proceed under the Environment and Land Code for a matter concerning illegal or irregular evictions, since evictions are required to have a specific period of notice, which is, I think, longer than 2 weeks and must fall on a day when rent is payable.
All right, thank you. So the last question to you, Nicole. What do you think is the difference between an instrument and a document in conveyancing?
So a document pertains to a document. Okay, let me just an instrument purports to transfer an interest in land. So an example of a document would be the standardized land registration forms, which are instruments to deal with various dispositions in land, including creation of a charge, transfer of a lease, transfer of a freehold interest in land, and such. While a document refers to documents such as the completion documents, obviously, as well as the sale agreement, which while may show evidence of a contractual duty, do not effectively dispose of that interest or alter that interest in land.
Well, thank you so much. I think my time is over with you, Nicole. First of all, thank you so much for volunteering to come, and you really performed so well. I'm really impressed. These are signs that you're really preparing for all these. I don't want to disclose marks as directed by my colleague Angelo, but you'll honestly pass. You will pass, I can assure you, if you perform this way. So quickly, just a review of the question. I note that you have answered all my questions, but then I note too, I think you are not able to get 2 correct. the question I asked you about distinction, or I requested you to distinguish between ademption and lapse. You defined vice versa. Whatever you define for lapse is for redemption, and whatever you define for redemption is for lapse. So that for redemption, let's say, for example, you have you're writing a will today, and you have this car. So you include this car in that will, but at the time of your death, this car is no longer part of your estate. So that becomes redemption. So that redemption is during the time of administration of your estate, some parts of the estate which were your estate are no longer your estate. You do not have the ownership. And then for the lapse is that the person you're bequeathing an item actually dies before the testator, so that the bequest lapse or lapses. So kindly go check on that. You can actually have various cases. There are several cases. Then the second question I noted you didn't get clearly was the question on the limited grant, the grant to apply. Of course, you're very right in the explanation, but it's not. I expected you to mention the type of limited grant. So I'll invite you to go read on different types of grants. But for this purpose, the grant you will apply is limited grant durante absentia. Durante absentia, so that you apply during this period when this person, administrator or administratrix, or the executor or executrix is away and is away in a foreign country. But you also have to be very careful. It could be a permanent absence or a temporary absence. You have to be careful about that. So I'll invite you to go read all types of grants, starting with the bonus on administratis, the SATE grant, pendente lite, ad litem, and really all sorts of limited grants, because you may be asked on any of them. Other than that, I think you have really performed well. All the questions were well answered. Unless you have any questions for me, I am 1 minute past my time allocated.
I don't have any questions. Thank you.
All right, thank you too. Back to you, Angelo.
Okay. Thank you. Thank you, Esbon. Thank you, Nicole. I would like to have the next volunteer. Please raise your hand. We are still over 370. Please, anyone? Daniel, can you see someone on your end? Yes, I have two. I will go with Mwiti. Is your network now okay? Because I was to
Yes,
go with Mwalimu Caroline.
Okay, yeah, can you hear me?
Or yes, I can hear you. So Mwalimu, you will Daniel will take you through the next session. So Eddie, thank you for making an effort again. My questions will also be straightforward, but one will require you to think. I believe we will finish our session at 2022-33. Okay. Mwiti, you are a senior economic advisor or the chairperson of the National Economic Council to the ASELA government. And now there is this bill known as Finance Bill. Soon it is going to be Finance Act. It has divided the country.
Yeah.
Now you have been invited to give a talk at the Kenya School of Law on why this particular bill is a good thing for the country. Can you please give us that talk in less than 2 minutes?
Okay, so the finance bill is a bill that the government aims to use to raise capital. As we've seen since the inception of COVID-19, many countries have been suffering financially. Economies have been doing badly. Kenya has obligations, loans to countries and multilateral and bilateral institutions such as the World Bank and the IMF, the International Monetary Fund. So considering all these, the government has to come up with a way of increasing its revenues without borrowing, considering that in the last regime, the tax, the foreign debt ceiling was actually raised towards the end to 9 trillion. So at the moment, the country is pressed for money, and that's why the finance bill is good. In this finance bill, will also help to achieve some of the economic and socio-economic rights under Article 43, such as the right to housing, which is designed in a way in which affluent or Kenyans who can will help the government fund houses for the poor or the struggling Kenyans, and this money will go towards the pension or will be refunded back after 7 years to the people who have contributed to it. As such, it's killing two birds with one stone. As Pierre Singer described, it's a sweetheart deal. You have poor Kenyans getting houses, and you have rich Kenyans investing somewhere or saving their money somewhere. And then there are also other issues such as if we tax everyone, we are taxing everyone, including those people who make money from online content. This is a substratum of the society which has not been taxed before. So if we are taxing Mama Mboga, we also need to tax such people. We also need to tax other business people. So the finance bill is a good way to show which brings proportionality to the way we tax, and also giving rights, those rights, the socioeconomic rights such as housing to the people. Thank you.
All right. You have, thank you for your opinion. I really appreciate that. But of one concern and something that you have mentioned, do you know the role, the different role that maybe a Senate or the National Assembly can play, especially with aspect to housing? Do you think that housing is a matter that is preserved to the National Assembly, or do you think the bill needs to be forwarded to the Senate? Or whom do you think is actually, whose role is it to build houses for Kenya? Is it the national government or the county government? Please, in another 1 minute. I know you have taken a lot of time, but please, a quick one. Yes, proceed.
Okay, so the work of the National Assembly is to make laws, and some of these laws or the bills which can be presented include money bills. The finance bill is a money bill. And so by now, the separation of powers, the way it works is that we don't have a total separation of powers because it would be impossible. So as such, it may not be the work of Parliament to construct houses. Those are policies left to the executive, since they are the policy-making body. But now the way in which some of these policies are realized is through the enactment of supporting laws. Hence, even though the national government is concerned with providing houses for its citizenry, the way which this will be realized is through a law such as this money bill, which is a taxation law, which now is rightfully before Parliament, because again, the president or the executive side of the government cannot create this law. That's why Parliament is passing the law. But now the money is to be realized. It's the executive which will determine what policies they should go to, and Parliament can vet those as the representatives of the people in case they feel that monies are being wasted or being utilized on things which don't matter, or with things which are not reflective of the people's wishes. So as of right now, the money bill before Parliament is rightfully before Parliament, and the policy that the government is pursuing is not illegal, it's not unprocedural, hence it is okay.
Okay, thank you. We have 2 more questions, and this one's now they are nail on the head. Give me 5 types of limited grants, quickly.
Okay, limited grants are provided in the 5th schedule of the Law of Succession Act. They are categorized in 3: limited either by time, property, So we have limited grant ad collegenda, which is we have grant ad collegenda, grant ad litem. We have a special limited grant, and then we have grant pendent elite, and we have a grant given by a magistrate to collect debt or pay out debts in his area under section
you.
49 of the Law of
Thank you.
Succession Act.
Thank you. Thank you. Please give me 4 challenges of using movables as a security under the movable property security rights. At least 4.
Okay,
Challenge.
one of the challenges is that we don't have comprehensive laws on IP. Another one is that IP valuation, because IP is one of the non-tangible movable properties. We have problems in valuation of the IP. Another thing is that this act is new, so we still have social perspectives or how people view it as is still not congruent with the objectives of the act. So people don't understand it. People try to get away with things. I will limit my answers to that at the moment.
Okay. If maybe it is my memory, or if not, therefore, my question is, can you please give me at least 7 judicial officers which President His Excellency Honorable Uhuru Kenyatta refused to appoint as justices of the Court of Appeal of Kenya?
In that answer, I'll be very honest. I know there were 42 judges whom the president refused to appoint after nomination by the Judicial Service Commission, but I do not know the names of any.
My question is, as I have said 7.
Yeah.
Okay, I believe 5 were to the Court of Appeal and 2 actually to the Court of Appeal. You have said that you don't know, or you don't have their names.
Yeah.
Very well. So finally, no, I have 1 minute left. I believe I can give my review.
Okay.
Muti, I believe you have read a lot, and that is why sometimes we are motivated by this lot of yours, and we are even afraid you will break our record because you guys are really studying, and really it gives us energy. You are cogent, you are really forthcoming with your answers. I would say you did extremely well. So with the aspect of judges, sometimes they will these people will always try to find something that to discredit you. Okay.
Yeah.
And these judges, they include Justice Joel Ngoge. We have Judge Vincent Odunga, Justice Agri Mshelule, Justice Weldon Koril. At the High Court, we have Justice Judith Orange and Evans Makori. So I don't know, for whatever reason, the president at the time refused to appoint those particular judicial officers. Okay. And the aspect of the constitution, and these are some of the discussions that will come up when you will be having your oral exams, especially this one, or the aspect of housing, which has been put in the finance bill. You see, under the constitution and the schedules, housing is a reserve of the county assembly. Therefore, it means that if a legislation that is going to be made, which is likely to affect the functions of a county government, then the Senate needs to be involved. We don't dispute that finance bill is a money, whatever bill, okay? But whatever that has been, this kind of tax, because the purpose that this tax is being charged or levied is to build houses according to the national government. But is it really their role? That is the question. Is it their duty? What does the Constitution say? And that is why you see right now questions are being asked, and actually that bill will be challenged. Some people now are overworking such that they can file a petition that is to have some sections of the finance bill declared unconstitutional. But that is a discussion for another day. So that is it on my own. On my side, I have nothing useful to add. Yeah, all I can say is that you did well, and I can, unless if you have a question for me, we are running against time. I would invite Daniel to take on our next speaker.
Thank you. Thank you. No further questions.
Yes, Mwalimu Caroline, you can unmute. Then Daniel, please proceed.
All right. Mwalimu Caroline, are you there?
Yes, I am.
All right. Kindly introduce yourself.
My name is Caroline Mwalimu. I'm in class C, morning class online. I'm in Form 11 and my registration number is 2023-0111.
All right. Any two reasons why you like online classes and one reason why you don't like online classes?
Two reasons. First, it's convenience. I'm able to attend classes from convenience of where I am. Second reason, I'm also able to continue working as I take my classes. So I'm able to work and at the same time also take up my studies. One reason I don't prefer online classes is the issues of network. Sometimes you're not able to, you lose network. Sometimes there's power outage and therefore you're not able to attend classes.
All right, very well. Mwalimu, which team do you support? Could be football, could be basketball, anything.
I'm not sure if wrestling is a game, but WWE is my favorite.
All right, interesting. Okay, so Caroline, what are the Siracusa principles?
Come again?
The Siracusa principles.
As I try to refresh my memory, maybe you can give me a second. I can go to the next question as I refresh my memory.
How will you be able to refresh your memory and still answer my next question?
Could you kindly, if it sounds like a Latin word, could you kindly interpret to?
Okay, Caroline, fine. We'll move to the next question, yeah? That's okay?
Okay.
All right. What are the modes of approaching the court? I know we have a plaint, we have a petition, we have a statement of claim. We have originating summons and the rest. If I'm filing a plaint today, what are the supporting documents?
You'll have a verifying affidavit. You'll have a list of witnesses. You'll have list of witness statements. Then we have list and bundle of documents.
What about a petition?
A petition, you will file, you will put a verifying affidavit also.
That's all.
And you'll also put your supporting document list and bundle of documents that you intend to use.
What about statement of claims?
A statement of claim, you will put a verifying affidavit and lists of documents.
All right, on to the next question. What are pre-litigation considerations? Let's say today a friend of yours decides to visit your chambers and they've told you this case, they want to file a case because someone decided to step on their foot when they're on a march to work, and
those shoes are worth 80,000, and she was going for an interview that day because she's seeking promotion, and because someone decided to step on her shoes, she got so mad to the extent that she failed in the interview. What are some of the things that you'd consider before you take on that case, before you go to court and file a suit?
First of all, we look at the viability of the case, that is, if he has a cause of action, and to establish whether he has a cause of action, we look at whether the facts of the case bring out whether there is a breach of a substantial law, and if there is any breach of a particular law, then we can look at the where we can file the case, that is where the matter arose. Then in terms of what we are seeking, we'll also inform the court we are going to file the matter. That is now if we are seeking damages, if we are seeking a particular declaration, for example, rights that can only be given by the High Court, then that will also inform where we are going to file the court. I can also check whether in the wake of the backlog of cases in courts, we can also check whether sorting the matter through a settlement, whether it's also an acceptable option for the client.
All right. Gisore Absalom, I think your mic is unmuted. Kindly mute. Gisore Absalom, kindly mute. Okay, on to our next question, Caroline. What is a garnishi order?
We haven't covered garnishi proceedings, but from what I've gathered, I would think garnishi order is where someone owes you money and there's another person that you know. For example, they have money in the bank and then you get an order from court so that you can withdraw that money from the bank. That would be my trial.
No problem. What's a test case?
A test case is filed where you have several claimants have the same claim, and they are seeking almost similar reliefs from the court. So instead of filing so many cases, for example, in the case of Ouru, I think it was in Mombasa. In case of filing so many plaintiffs filing so many cases, so you will use for example, one person, and then the particular reliefs that the court gives in terms of damages, then you can use that judgment of court to obtain the damages. So in that regard, the extent of liability may be the same. So a test suit is used to determine whether the viability of a matter, instead of filing so many cases in which you will obtain different judgments, so you are able to test whether you have a claim or not.
All right. Do you know anything about the case of Anarita Karim in Njeru?
Yes.
What is it about? real quick.
And Anarita Karimi Njeri is about precision of filing matters. When you're filing cases, being able to define draft court proceedings with precision.
Draft proceedings or draft pleadings?
Drafting of pleadings with precision.
If you don't draft the pleadings with precision, then what does Anarita Karimi propound?
So Anarita Karimi, if I might try, from what I can remember, they're basically saying that the court is not able to provide what is not specifically pleaded. The same has been challenged in the wake of the Mutunga rules, where the court may provide any other order that may deem fit.
Yeah, all right. So what is a preliminary objection?
A preliminary objection is an application filed in which it is able to dispose of suit in its entirety. Basically, for example, an appeal may be on the ground that a court does not have the jurisdiction to determine the case, and in that case, the case is disposed of completely in that court.
Any case that comes to mind?
I think the case of
You think?
Tononoka case.
You think? Am I sure?
I am sure. The Tononoka case, where the case is known in terms of advocates' remuneration fees, but in that case, the court struck out, dismissed the suit because it did not have the jurisdiction to determine the matter.
All right, fair enough. Kindly explain to me the three different types of searches. Now this is conveyancing, and why an official search is not only important but different from the other searches.
We have historical search, the official search, and then you'll have the, I would call it the site where you physically go to the specific place where the land is located. The official search is specifically important because of the principles. I'll just explain what the principle basically says. I can't remember the actual word that is used to describe it, but basically come again?
The Torrance principles, you mean?
The Torrance principle, yes. Basically, the official search is one that it is a final, and it gives the person who made decisions based on the official search the legitimate expectation that the whatever information in the official search is final and it is a correct one. And if you go to court and you're basing your claim because of the contents of the official search, the court is likely to rule on your favor.
What if it doesn't? Yet you did an official search.
If it doesn't, then it would mean, for example, in the case of conflict in titles, then it would mean you were a purchaser of value without notice. And case law has taught us that there are certain remedies that such persons have in law.
Which are?
For example, in the case of Taj Taj case. The
What do you mean Taj case?
I'm trying to remember the exact name.
No, okay. Well, just say what does the case say? In a decided
So-
case, for example.
So the remedy there was the registrar who was responsible for the mistake was supposed to compensate the purchaser or value without notice.
The registrar in their own capacity.
Yes.
All right. That was my last question. You've done well. I like the confidence. Try your best not to do the try your best not to do that. Just try and breathe, calm down, and answer the questions. Now, the reason why I asked you whether you think or you know is because you started saying you think. Again, where you're not sure about a case, just say in a decided case, it was held that this. I know you're looking for the Gitwanyi versus Tajimol case, but you aren't able to get it. So try and just say in a decided case, it was held that this, where you can't remember the case. Or rather, where you start saying the name, but then the name disappears. Because if you tell me the Taj case, which one is that? Because it's, it's Taj Mahal. So yeah, where you forget the name and people forget, sometimes we do, especially when there's pressure. So just say in a decided case, it was held that this is. I'm sure the lecturer will remember. Now, there's a question that I asked you in the beginning. When I was asking you this question, I didn't expect you to have answers, and so that's okay. But what I was looking at is how you are going to reply to that particular question. Okay. Now, if you're asked a question that you have no answers to, you have no answers at all, what you tell me is, I'm sorry, I'm not aware of the Siracusa principles. However, after this session, I'm going to do my research and ensure that I know the principles. Simple and clear. I can't take you anywhere. You don't know, but you've promised me that when you leave the meeting, you're going to do your research and ensure that you know them. I will easily move to the next question. Then you saying pass. I don't know, and every other thing. Just say, I'm not sure, I don't know, I'm not aware of the Siracusa principles, but after this session, I'm going to do my research and ensure that I know the Siracusa principles. Full stop. Okay, so where you have a question that you don't understand, that would be your defense. Again, I'm not saying that you have to keep saying that. If you have a better way of dealing or of answering that question, well and good, you can also do that. But in my opinion, I believe that is, a very conventional way of doing it. Now, what are the Siracusa principles? Now, Siracusa principles are related to Section 21 of the Constitution. They include restrictions of a right, restriction of rights or limitation of rights. So it says restrictions of rights should at minimum be provided for or carried out in accordance with the law, directed towards a legitimate objective of general interest or public interest, strictly necessary in a democratic society to achieve the objective. It must be the least intrusive and restrictive way available. It must be done in the least intrusive and restrictive way available to reach the specific objective. They must be based on specific evidence and should not be arbitrary or discriminatory. Must be applied within a limited duration, respectful to human dignity and subject to review. Now, these are principles that are applied, for example, where we have outbreak and people need to be quarantined, like when we had Corona and all. These principles would really apply. Of course, Section 20. Not Section 21. Sorry, Article 21 of the Constitution also, which talks about limitation of rights. I just want to be sure. I don't want to.
Article 24.
Yeah, Article 24, which talks about limitation of rights. I don't want to mislead you. Yeah, Article 24, which talks about limitation of rights. So The Article 24 stems from the Siracusa principles. The Siracusa principles came before Article 24, so they were just derived from that. Modes of approaching the court: plaint, petition, statement of claim. I think those ones are easy. Then pre-litigation considerations. Caroline, I think you are thinking so much about this, but this include course of action, which I think you got correctly. Limitation of actions. We have feasibility of the lawsuit, which you talked about. Then we have ethical considerations like conflict of interest and the rest. Okay, and other issues, but you can just go with the 5 for now. Ethical considerations, feasibility of the suit, whether the matter has been decided or still in court. This is I'm talking about sub judice and res judicata. Then limitation of time. Then we have course of action. Any other thing? Preliminary objection. I was thinking that maybe you'd talk about the Mukisa Biscuit versus Western distributors, but you didn't talk about that, and that's okay. Ganishi, you said that you haven't, but okay, your content on what a preliminary objection is was okay. That was fine. Ganishi, you've told me that you haven't done it, but you tried to explain. Now, this is where you go to the Ganishi, the bank, okay, where you have a decree, and the person who you have the decree against doesn't want to pay. But you know this bank where this person has particular amounts of money. You can always ask the court to give you an order so that those particular monies in that particular bank are marked and sent to your account so that the JD or the person who owes you money pays you the monies directly without struggling here and there for no particular reason. What is a test case? You tried to explain this, and I think your answer was not so bad. But a test case is where so many people have filed different cases, but the court listens to the first one, and after making the decision of that particular case, that decision is used as the decision for the remaining cases. Okay, so you must be able to differentiate between a test case and how do you call it? Class actions. The difference is very small, but you have to be very, very careful so that you're able to differentiate between those ones. So, of course, the facts are the same, the laws used are the same, but in a test case, we have several cases in relation to the same facts and the same issues. But after one case has been decided, that decision is used to decide all the remaining cases. So the courts won't listen to all the other cases also. Then we have Anarita Karimi. This is about striking out and defective pleadings. And I think you said it clearly that it's about precision, that there are things that you have to include in a constitutional petition. And in this case, those things are not included. And the judge decided to throw out the case or to strike it out because those things are not included. Now, I don't know whether we'd still go with this today. Of course, in the wake of cases like DTDOBI and Company versus Mushina, DTDOBI and Company versus Mushina, where they said a case should only be stricken out where it is so weak, it is very weak to the extent that an amendment to the pleadings wouldn't help it survive. This is a debate that we've had for a long time, and I want to believe that yes, it is important for lawyers and advocates to draft their pleadings with precision. It is important that they're very careful when they're drafting them. But again, I don't understand why you should just strike out a suit because someone has not done that. I mean, I feel like it should be, we must strike a balance. Yes, that's all. That's all, Caroline. Do you have a question for me?
Yes, the last case you mentioned, could you kindly
DTDOBI Company
on the chat kindly?
Yeah. Yes.
Could you kindly post it on the chat? I
Yeah,
can't
but
pronounce.
it's just DTDOBI and Company versus Mushina. Mushina, Muchina. It's nothing complicated.
Then how would you differentiate class suits and representative suits?
I'm not sure whether there's a difference between the same, but I'm sure there is. Allow me to get back to you probably, maybe next time. How would you differentiate the two? Caroline, how would you differentiate?
Maybe someone can help in the class, but I've tried looking for the difference. When the lecturer was teaching, she seemed to differentiate the two, but I have actually not found a difference.
Akumu, go ahead.
Good evening. My name is Eugene Akumu. Actually, I share the same sentiments with her because when you look at both the suits, you'll find that there's a class of plaintiffs who maybe want to sue in regards to the same subject matter or the same issue. So instead of admitting all of them, and the ground you'll find is that there's always a trustee as regards to the plaintiffs. So maybe the trustee is
representing all the other people.
So I also asked the same question in class, and to me, they are more or less the same. I don't
What did
see
the teacher say when you asked the question?
Actually, I asked her with regards to instances where a trustee in probate matters applies for a grant ad litem. You know that in such a circumstance, you'll find that it's always a petition under Form 90 accompanied with a verifying affidavit. So I asked her whether it assumes the form of a representative suit, because there is a class of plaintiffs here who are the beneficiaries to the estate, and now the trustee, the personal representative was taken out the grant ad litem, and she actually said that that type of suit does not assume the form of a representative suit, the petition, when you are applying for grant.
All right, so you have the same issues. Allow me to get the difference. Yeah, maybe in the next class. I think for me right now, in my mind, the difference is the same. I know that doesn't make sense. Nicole, any other question? Yes, someone can assist. Go ahead. There's someone who has said they can
Hello,
assist.
Mr. Duar.
Yes, go ahead.
Hello, can you
Go
hear me?
ahead.
Okay. Allow me to take the concern of the of majority of the people of the differences between a representative suit and class action suit. I remember last year I was in the team that was tasked to look at the difference, to research on the difference between the two. And first of all, guys, before we go any far, is that all class actions are representative suits. That is the first thing you should know. All class action suits are representative suits, but not all representative suits are class action suits. So that is the first adage I want you to get. So now the question arises, what are class action suits? So from the word class action suit, or rather what is common in these two types of suits is that there is a common cause of action. Sometimes the claims may be same, arising at the same time at the same place. But then the key distinction between the two is that in class action, you look at the class of persons. A good example could be a class of employees of a certain employer, a class of members of a certain insurance company, a class of members of a certain agency. So if this class of persons, or for example, a class of persons, students of Kenya School of Law, all of you are students of same class, then if one of you takes up the matter to represent the rest in court in seeking some, in obtaining some, or rather in presenting some claim, then that shall be called a class action. So that the reference is the class of persons you are representing. They are persons of same class. When you talk about the representative suit, it can be a class of different persons. For example, let's say, for example, which example I can give is, pardon?
No, go ahead. Go ahead.
Okay, sorry, I thought someone was speaking. So for example, an accident case, an accident suit, and I'll refer you to Order 1, Rule 8. For example, in an accident case, there is no class of persons in that scenario. You're just representing different persons with in seeking the claims. So in that case, it will be a representative suit. Another type of representative suit will be, for example, a minor wants to sue, and because he does not have capacity to sue, you go represent this minor. You know, for example, a guardian ad litem and next friend. So if you do that, you'll be a representative suit. And for example, another one can be where a person is dead and you as a legal representative, you take out grant for that person. You are also you're also conducting a representative, or rather, whatever you're doing is a representative suit. So I hope so that will bring a clarity that in class action, you look at the class of persons who are claiming. They are persons of same class. On the other one, it is just general. And that is why I started by saying all class actions are representative suits, but not all representative suits are class action. Thank you.
Okay. Thank you so much for that distinction. I hope we understand that. Someone could argue that even those people of different classes is a class of victims. But anyway, that's a story for another day. Guys, I think that's it. Any other questions? Angelo, would you like to take other questions from the team?
Yes, no problem. Who is talking, please?
It's Oruko. It's Jacob wanting to confirm something.
Yes, please, Jacob.
Yeah, let's assume this case we had in Solai Dam. Let's assume a case like the Solai Dam one. Can we classify that one as a class suit or a representative suit?
Esbon, maybe you can answer that one quickly.
Angelo, I think from okay, Hezbon, you want to answer. But I think from what Hezbon has said, that would be a representative suit because these people from Solai Dam, they're different, they're people from different classes. We have farmers, we have all types of people in that particular group. So I want to believe that would be a representative suit. But anyway, Hezbon, do you associate yourself with my sentiments? You have a different answer?
I associate myself like a judge.
Very well.
Very well. So now, Daniel, I don't know, we have 4 hands up and time is not on our side, and we promised them that we won't go past 11 p.m. What do?
We can lift that order. let them ask their questions quickly, just one question.
Right.
Yeah.
All right. Lim Thomas, please ask your question.
Yeah, thanks, Angelo. I'm going to ask my question pretty fast. The first question is related to you, and it is an observation on the questions that you are asking, and it also ties with one of the questions that Daniel asked. You asked a question on naming 2 types of computer hardware, and that is one, and you also, there is somewhere, and that question also marries with what Daniel asked some question, which in my view, it felt like what will be, yes, when she was asking about the teams that somebody likes, and I was trying to question what is the legal relevance of that question, which authority will we anchor that question. So I needed your guidance on that. Then secondly, when you are asking a question on that, this is the second question now to Angelo. You asked a question on naming 7 judicial officers, and he went ahead and mentioned them. And my mind quickly went back to the definition of a judicial officer as provided in the Judicial Service Commissions Act, which does not include the judges. And therefore, I thought of what if, because of that provision of the law, I say, okay, there were no judicial officers that the president refused to appoint because judges are not defined as judicial officers. What will that be like? Will I be correct? How will that kind of presentation be taken? Anyway, for the interest of time, let me, because I had indicated, but because of the constraint of time, I will ask if time will allow the other question. Yeah, those two questions. Thank you.
And Thomas, and you can keep the other questions for the beginning section, the beginning part of the next session. Okay, so maybe you
All
can.
right, well guided.
Yes. So, Alafu, let me ask the first question, then you can ask the second one. The question on the teams that you like. I just wanted to create banter with the volunteer, and I was just trying to help them calm down. There's no legal relevance there, and you don't even have to give me a particular answer. You can say anything whatsoever. Okay, so I was not looking forward to anything, and I don't need an authority. I was just asking it to calm them down. Thank you.
Okay, Lim, thank you for your questions, and they are interesting one. I don't know whether I would say that it is ignorance on your part in that respect, because especially on that aspect of hardware or computer, actually it is examinable legal practice management. Okay, and maybe you have not reached there yet, but it is part of your course. So there is no authority to that respect, but it is part of your course outline. So maybe you have not reached there yet, but yes, it is part of your program. Okay? So that is what I would say.
I agree, it is ignorance on my part. That could be LPM.
Yes. And maybe the reason we don't answer a lot of LPM questions is because sometimes most lecturers, they don't ask. But when you meet one like is it Monde or Munde? There are several of them. Of course, you will be asked these questions. Okay. So I'm not. Please don't take it other way. I'm not saying that you are ignorant, but yes, I was.
No.
That is
well guided. Well guided. Well guided.
Okay.
Thank you.
And on the aspect of the judges, maybe I can also say it is ignorance on my part. But if I remember very well, I said justices of the Court of Appeal. We also call them judges of the Court of Appeal or judges who are to be appointed. Okay? Among them included 2 judicial officers who were at the time deputy registrars. Okay? But if you look at the schedule there too, to the Judicial Service Act, I don't know if it is Schedule 3. If you look at the discipline of the judicial officers, this include the discipline also to judges. But it is correct when you say that judicial officers are different from judges. Okay? We also have magistrates. Okay? So I would say you are correct to that respect. All right? I don't know if I have answered your questions because we are running very fast.
You have. Thank you.
Okay, thank you so much. And please study LPM because we'll have a lot of pressure during orals. Mwenda, 1 minute. Tafadhali. Then Onyango, then Alice next.
Yes. There's a question that I had asked. I have 2 questions. There's one that I'd written about the issue of talking about sentence bargaining, plea bargaining, and I thought it was a bit it was the contrary of what I've seen in some judgments and what I've heard in some courts, and because you cannot, I am of the opinion that since it is the prosecution that carries out plea bargaining, we cannot have a plea bargaining with regards to sentencing. But I would request for the opinion of Daniel because he's the one who stated that. And then on the issue of, there's a question that Eddie was asked about the propriety of the finance bill. And I also had, the person who answered stated about the issue of, this is an issue of county governments. And I had also had Mr. Otiende Amolo saying that, but if you look at the 4th schedule of the Constitution, it states that the issue of housing policy belongs to the national government. And as such, if it belongs to the national government, I am quite of the opinion that it is the National Assembly that has the responsibility to legislate about that. So I would request for your opinions and for your further guidance on that issue. Thank you.
Thank you. Odor, please.
All right. I think I agree that your whatever your question on sentencing is quite important. But I'd like you to note that the court can reject a plea bargain agreement. Now, what does this mean? It means after having this plea bargain agreement between the parties and everyone else, this agreement, or to some extent, the magistrates must be involved at the end of it all. And it is during this time, because if you're talking about the court can reject the plea bargain agreement, it means at some point they are involved in this matter. And it is during this time when they are involved that they can reject or agree with it, that this issue of sentencing could be, agreed upon. And I mean, there's freedom. If so long as the magistrate is okay with it, so long as the judge is okay with it, so long as this one ensures that justice still prevails, then why not? The judge would agree, or the magistrate can agree. Now, they can also refuse, because again, it is their discretionary power to decide on sentencing. But I'd just like you to note that the court can reject a plea bargaining or agree to it. Meaning, before this thing even go to court, before this charge is changed, before all these things are done, the judges are consulted. Thank you.
Okay, Mr. Daniel, just a bit of a fallback question. If you look at section 131A of the CPC, it states the parameters of a plea bargain, and it is restricted to the first two issues which you stated, the issue of the charge and the issue of facts. But it's okay. Yeah, thank you.
It is well. It's okay, Victor. It is well. I think you can also go with the two, or you could add the third one. I don't think there's any problem with adding the third one. It wouldn't negate the two. But if you are right, then you could get 3 marks.
Okay, thank you. And the issue of housing, kindly.
Okay, and Angelo, we said one question per person, man.
Okay.
Maybe we could answer this, then the next person should ask one question.
Mwenda, we will defer answering your question to the first minutes of our meeting next week. Is that okay? Because we need to be fair to your colleagues too, who are still in the meeting.
That's totally in order.
All right, thank you. Onyango, take it away. Then Alice. Then yes.
Okay.
One question.
Thank you very much for the fruitful discussion. I've learned a lot, and I think my life will not be the same again. But I have a question concerning the first interview, where the issue of review and appeal was I never got it correct. So if you can briefly elucidate on it, appeal and review, because I understand there's revision, judicial review, and appeal.
Okay. All right. Nyambura, are you there?
I am. When it comes to the question was on review and judicial review. We said review is where the same court actually reviews a judgment if there is any new evidence that has been brought, or there was a mistake on the face of the judgment that was issued. That is what we call review. Now, that is normally done by the same court that issued that judgment. When it comes to judicial review, you're applying to the High Court for, normally it's 3 orders. We have an order of prohibition, you have a quashing order, and you have an order of mandamus. You're telling the High Court to prohibit a body from doing something. You're telling the High Court to quash a decision that was made by a body. It could be a statutory body, it could even be a university, it could be a body that is not a court of law. Then the other thing, you can be telling the court to compel a body to do something. Mostly compelling orders in judicial review proceedings are against the government, where probably you have an order against the government and they've refused probably to pay you. So you institute judicial review proceedings for the court to actually compel the government body to pay you. So basically, judicial review, you're asking for those 3 orders. Review is a decision of the court, and you're telling the court there was a mistake on probably your judgment, or I have found new evidence that I didn't have. You use it. Revision is a whole different thing. We talked about it. That is, the same court can revise, or the High Court can revise the decisions of a magistrate's court, and that is in criminal litigation. So basically, that's it. That's the difference. Appeal is when you probably have a judgment from the magistrate court, so you're appealing at the High Court, or you have a decision of the High Court, you're appealing at the Court of Appeal. Basically, you're going to the next court. You're not going back to the same court that issued that decision. I'm sure you'll get there. You haven't, I don't know whether you've done appeals, but yeah, you'll understand it better when you do it. But basically, in appeals, you're going to the next court.
Okay, thank you. And in that JR, if you are not satisfied with the decision of the High Court, are you allowed to appeal it, or it is final with the High Court? Thank you. That is
You
my
see,
last
the
question.
decision, okay. If a High Court makes a decision, it becomes like a decision of any other court. Like a decision any other High Court. I mean, like a decision that is normally made by the High Court. So you can appeal that decision of the High Court at the Court of Appeal. So nothing bars you from appealing. It is now a decision of the court. You are appealing and say the judge erred in law or in fact.
Thank you very much. I understand.
Yeah.
Okay, thank you. Thank you, sir. But now, please, you need to peruse your civil procedure and civil rules and the act. You need to look at section 80. You need to look at order 45, such that you can appraise yourself with the aspect of review. If you need to look about judicial review, you have to know there is 2-track system, whereby those that you use order 53, where you use section 8 and 9 of Law Reforms Act, and there is that one that you do apply pursuant to Article 23, Article 22, Section 11, or maybe let's say Fair Administrative Action Act. Okay, so that one, it will assist you in that way in handling those things. Thank you so much. We go quickly. The other one, Alice, are you there? Please unmute.
Hi, good evening.
Good evening.
Thank you for the session. So mine is just a confirmation. Our lecturer, civil litigation, has asked us about the number of judges in Kenya twice now. And I have Googled and have not found any. Can you guide me on the same kindly?
Number of judges in which sense? How many judges?
The total number of judges in Kenya.
Interesting, interesting. I don't have that in mind, but I believe there is a quite number of judges. Esbon, you have idea the number of judges we have so far?
Honestly, I do not have the record. Unless I confirm that in the next session, I'll be able to respond with precision.
Okay, okay. We will need to confirm because it is a matter of numbers.
Okay,
thank you.
To answer that,
Yes.
Hello.
Yes,
The
yes.
last time I googled, I was told that there are 540 in number, not 540. That is comprises the number of magistrate, judges, and the judges. So, but it never gave the exact number of judges.
Oh, okay. All right. Thank you for that contribution. Is it Milton or who? You just
Yeah.
raise your hand.
Yes, it's Milton. I think the last time I googled, the number of judges is 62, and there's a recommended maximum of 200.
Okay.
Yeah.
Thank you. Thank you so much. Anyone that we have locked out today?
Angelo,
Yes, sir.
to respond to the request by members, kindly allow me to confirm the same so that Saturday we have exact number, because I understand the yellow pages usually are typed, or rather are publicized at different times. So we may not get exact number of judges by relying on the yellow pages, but maybe we can have reliable persons who can have exact numbers. So I will request the members not to go by whatever we try to respond in terms of what we Googled before, but maybe to go research, and we see if next Saturday we'll have the same number.
Very well. Very well. Very well. Gogi, M.
Good evening.
Good evening.
Yes, I have a question.
You are
But
not
I did.
clear.
Hello, I'm saying, or something that you are explaining about changing Firefox principles or something like that. If you could please go through it again for me to get what you say.
Okay. I haven't heard you quite clearly. But Daniel, maybe I believe he's asking something related to Article 24.
Yes, Ngugi, the Siracusa principles are related to Article 24. They are the rules and the guidelines you have to follow when you are limiting any right. If you Google, you'll be able to find them. If you Google, you'll be able to find them, all of them. So maybe you can just check. Siracusa is Siracusa, Siracusa principles. That's okay?
Okay,
All right.
very much. Okay.
All right. Then Milton, when Hesbon said that we'll confirm the number of judges, you're not saying that your number is wrong. Probably when we confirm next weekend, it will just be the same thing. Probably.
Okay. Totally.
All right.
Okay.
All right.
Thank you.
Yes, then our last person today, please, David. Maybe in 1 second, we will close at 23:30.
Yeah,
David.
Thank you so much, guys, and thank you everyone for your participation. I wanted to provide some light as far as the number of judges is concerned. Now, the Constitution of Kenya provides that at 165(1), there is established a High Court which shall consist of the number of judges prescribed by an Act of Parliament. Now, that Act of Parliament is known as the High Court. Let me just give you the right citation. It's called the High Court into bracket Organization and Administration Act 2015. Now, part 2 of that act, section 4, I hope I'm citing, yeah, it's an act, section 4 says, the court shall consist of the principal judge and not more than 200 judges appointed in accordance with Article 166, 1B of the Constitution. So now, when the lecturer asks the number of judges, I'm not sure whether they're asking as per the proviso or the actual number of judges in the judiciary. Maybe that is something the person needs to confirm with the lecturer. Thank you.
The lecturer asks the actual number of judges right now, not according to the provision.
Then in that regard, that might change, given that you need to find out. And then again, the number of High Court judges or all judges, because we already know the Supreme Court has 7, the Court of Appeal has not more than 30, then so those are already filled up. So what we need to find out then now, therefore, with the judiciary, and this is information that the judiciary can only provide, is the actual number of judges in the system. And that information maybe probably you need to get it from the judiciary. So thank you.
Okay, thank you guys. We are only 1 minute away. But Daniel, I think I will not defer this question on the issue of housing to next week. Maybe we can start on something new, but I would like to refer, I don't know who asked me the question, to part 2 of that schedule 4, and specifically, okay, and specifically now to, is it paragraph 8 of part 2, whereby county planning and development, which now it includes housing under paragraph D. You are right when you are talking about the policies, they can do that. But when the national government is saying that they will build houses for the people, that role now is left to the county government. Okay, the policies is left to the national government, but the actual work, which our very own president has been saying, the aspect of building houses, that one is reserved to the county government. That is pursuant to that schedule 4. I don't know if I have answered your question, such that we can say tumemaliza vizuri leo.
Yes, you have. Yes, you have. Thank you very much. You said part 2 of?
Part 2 of schedule 4.
Thank you very much. Be blessed.
Yes, thank you. Thank you. Let us pray. Daniel, is that okay?
Yes, just a few sentiments. Guys, thank you so much for joining today. And we like the numbers. We like the fact that you guys are pushing, that you guys are doing your best. Now, we're just people like you. When we're having these discussions, please be free. Don't sit somewhere in a dark corner waiting to hear people giving their answers. Once in a while, put yourself in that seat and see how you'll do. You remember when we had John Garang, he explained very well that when you are asked those questions, sometimes even the answers disappear. Imagine if it is your first time and you're asked these questions and the answers disappear. And the answers don't disappear in this platform, the answers disappear during your orals exams. So please, the more you practice, the better you become. Let those answers disappear here. And the more we practice, the better you become. So that when you're doing your orals, no answer is disappearing. Why? You have learned how to survive in that particular environment. So please, I'd just like to urge all of us, to charge all of us to try our best and just put yourself out there. I'm telling you what, this thing will not kill you. It has never killed anyone. It will not kill you. It will only help you. You'll only get better. At least try that before that date, before you're doing your orals exams, at least we have asked you questions twice or even once. At least try and ensure that you've gone through something like that before you actually go through it. This will help you improve. This will help you. I promise you, it will help you get better. And that is our intention here, to practice, 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 and practice. We are not here to shame anyone. That's why I keep saying, do not be intimidated by anyone, not in any way whatsoever. That is not the reason why we are here. So I want to encourage us again, put yourself out there. Use this opportunity. It is yours. Take it with the 2 hands. And I want to believe, and I want to know, and I want to agree that you guys will do better. You guys are really studying. I love it. You guys will do well. Please, please, please. Practice, practice, practice. Don't care about anything. Don't care about anyone. When those results come, I'm telling you, they are yours. They are yours and yours alone. They will not even belong to me, Angelo, or Hezbon. They are yours. So if you get this opportunity, take it, and take it with 2 hands. All the best, guys. Enjoy your weekend. Have a good week. Angelo.
Okay. Thank you so much, Daniel. And by the way, guys, take it serious, like whatever Daniel has just said. I remember very well my first session. Our group back then was no 9-piece gang. It was actually not good, but I actually later listened through how I performed because my answers were everywhere. There was no precision in my answers, no section of the law that I quote, like my answers were just everywhere. But I ensure that every time that I'm called out, my hand is up. If I'm not the first person, I'm the second person. So, guys, please, I really appreciate your numbers today. It was really good. It is a testimony. We passed our CLE exam, and it is not just that aspect of passing, just getting a 50 plus, or you just pass. It is something called like passing. Okay, so guys, I know you guys will really do well, and please take note of conveyancing. Half of my colleagues, about 623 or thereabout, I'm not sure, they failed to get 9Ps because of conveyancing. We put in a lot of time, and then exam was marked by land grabbers. So then it really became an issue. So please put in time, and hopefully we will all smile and we'll enjoy together when the time comes. Review your project work. Please don't submit it that way. Sleep at 5 if need be. Okay, don't leave it to one person, because it was the work that we did with project work and orals that maybe some of us have the best marks available in our transcripts right now. So please pass these 2 exams, and you will celebrate when you will be doing your bar examinations. So Wairimu, if you may, you raise your hand, if you may allow me to pray, if that is okay.
Wairimu, let's have you in the first minutes of our second session. Just keep your question. We'll have you then.
Thank you, Senior. Our Heavenly Father, we thank you this evening, this night, for these students who have joined in today, who are really preparing for the exam. Please bless them as they study. Give them wisdom, give them knowledge to be able to understand everything that they are reading for. All the panels that they will appear, please, whatever that will be asked, let it be something that we have practiced today. Continue to guide them, continue to give them energy as we pray shortly, as we believe. Amen.
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 Good night, guys.
Bye, guys. Good night.
Thank you very much. Have a
Amen.
good day.
Good night.
Blessed week ahead.
Thank you.